Good morning. Can you all hear me okay? Can you hear me in the back? Okay. We're going to go ahead and get started. First, I just want to informally welcome everyone to this year's Language Access CLE, Eliminating Barriers to Justice 2, How and Why to Ensure Language Access for Limited English Proficient and Deaf and Hard of Hearing litigants. A few housekeeping matters in case you missed it. If you elected to access materials on your personal device, the network is lowercase BCC guest 1 all together, and the password is 0326. Oh, I'm sorry. I'm corrected information. The network is JMLS, but the login is the BCC guest 1, and your password is 0326 2015. Today's date, 02/26/2015. If anyone needs to use the restroom, there are out of these doors here or the doors in the back to your right for both men and women. And now I will go into our welcome. Chief Justice Thompson had wanted to be with us today, but unfortunately could not make it. But he was gracious enough to send a video message for us. And so I will first just read a little bit of his bio for those of you who may not be familiar with him. Chief Justice Thompson is a native Georgian and current resident of Milledgeville and was appointed to the Supreme Court of Georgia by Governor Zell Miller on March 1st, 1994. Prior to becoming a justice on the Supreme Court, Justice Thompson served as Superior Court judge in the 8-county Ocmulgee Judicial Circuit, having been appointed to that position in 1979 by Governor Busbee. He was re-elected repeatedly by the citizens of the Ocmulgee Judicial Circuit and served from 1979 to 1994. He served in the capacity of Chief Judge of the Ocmulgee Circuit from 1987 to 1994. Before his appointment to the Superior Court, Justice Thompson served from 1971 to 1979 as both Judge of the Milledgeville City Court and Judge of the Baldwin County Court, now known as the State Court. From 1969 until 1979, Justice Thompson was engaged in the general practice of law in Milledgeville, Georgia. He received his legal education from the Walter F. George School of Law at Mercer University in Macon, earning his Juris Doctorate degree in 1969. Justice Thompson received his undergraduate training from Emory University in Oglethorpe University.
Good morning, everyone, and thank you, Jana. On behalf of the Supreme Court of Georgia, I'm honored to welcome you today to a series of discussions about how we can increase language access throughout Georgia's courts. Winston Churchill said, "We make a living by what we do, well, we make a life by what we give." I believe that each of you who is here today has a deep commitment to improving access to justice throughout our state. I believe it is the job of every attorney and judge to do all we can to ensure that all people, no matter their background or native language, have access to our courts. And I want to thank each of you at the outset for doing your part. As I said not long ago to the Georgia legislature, those of us who grew up saying the Pledge of Allegiance at school promised liberty and justice for all. Now, I don't believe we ever meant liberty and justice only for those who can afford it, only for those who speak English. Equal justice for all is the promise embodied in our Constitution, as envisioned by our forefathers. The late Supreme Court Justice Lewis Powell called equal justice perhaps the most inspiring ideal of our society. As lawyers and judges, we are ambassadors of our profession. We must always conduct ourselves with dignity so that our character is beyond reproach. We must treat our clients and our opponents with courtesy and with respect. Most importantly, we must do all that we can to improve our society. These are the fundamental components of professionalism. As Georgia continues to grow in population and diversity, I believe another component is the work we do to ensure that all people have access to justice, as our laws were not made for just a few. As you know, too many Georgians lack access to the courts because they are poor, or they don't speak English, or they live in areas of the state that have no lawyers. According to the National Center for Access to Justice, when it comes to access to attorneys, Georgia ranks in the bottom 10 states. Georgia's population now makes us the 8th largest state in the country. We are growing rapidly, and just as our medical profession is gearing up for our future growth by ensuring we have enough doctors and hospitals, and just as our state government is looking ahead to ensure that we have enough water, schools, modes of transportation, and trained workers, likewise, the judicial branch must prepare for the future. Georgia is a growing hub for the international business, and today home to more than 3,600 foreign businesses from more than 60 countries. We are home to an international airport, the largest in the world, and we will continue to attract individuals and businesses from many different countries. To prepare for the future, Georgia's courts need an army of trained, certified interpreters. Today, 1/5 of our country's population speaks a language at home other than English. In Georgia, the Administrative Office of the Courts estimates that more than 500,000 people do not speak English, or they speak only limited English. Providing interpreters is an ongoing challenge in the courts across the state. Last year, DeKalb County State Court Judge Dax Lopez told me that he was having to take criminal pleas with the help of Thai, Korean, and Burmese interpreters. Judge Lopez and other judges have found that even identifying the language a defendant speaks can be a challenge. Currently, Georgia has only 156 licensed court interpreters for the entire state, and they speak only 12 languages. That's not enough. Under the able leadership of my colleague, Justice Keith Blackwell, who will deliver your keynote address this afternoon, the Georgia Supreme Court's Commission on Interpreters is trying to increase the number of certified interpreters and the variety of languages they speak. But interpreters must do more than simply speak the language. They must also understand legal terminology and their obligation to protect the confidentiality of their clients. Justice Blackwell, assisted by the Commission's Director, Sinji Murakami, hopes in the next year to work with local judicial circuits in identifying the number of interpreters they need, the particular languages they need, and how we can best help them. As Margaret Mead said, never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it's the only thing that ever has. All of you here today play an important role in ensuring access to justice for all of Georgia's citizens. So I thank each of you for doing your best to maintain the high standards of this most honorable profession, the law. And on behalf of the Supreme Court of Georgia, thank you, each of you, who are in the trenches with us for all you are doing to improve language access in our court system. Have a wonderful day.
Okay, so I see we're filling in a little bit. Let me first introduce myself for those of you that I didn't get a chance to speak to personally as you were coming in this morning. My name is Jana Edmondson Cooper, and I'm a bilingual staff attorney with Georgia Legal Services Program in the Macon office, and have the honor of serving as one of your co-chairs of this CLE event today. My other co-chair, Bernadette Almost, did she step out? Is here. She has on a green jacket. And also Lisa Kreischer, who is the Director of Litigation for Georgia Legal Services Program. We also want to make sure that we recognize our title sponsors, who are Georgia Legal Services Program, A.B. Almos and Associates, and the Chief Justice Commission on Professionalism. We really, really appreciate their support, and as well as all of our other sponsors, those who are contributors and our supporters, which can be found on the back of your program. So just to get a feel for who we have in the room, how many attorneys do we have in the room today? Okay. How many of you who are attorneys are in private practice? Okay, public interest. Other. Okay, a few others. Do we have any judges in the room? We won't pick on you, it's okay. Okay, we'll have some later. Do we have anyone, do we have any interpreters? Okay. Anybody else that I didn't think of? Any paralegals? Do we have any folks with the government? State or federal? Okay. Okay, that helps. So we're going to get into it. I want to be respectful of you all's time. We will break for lunch, and at that time, lunch will be served down the hall in the reception area, so you all will be free to go there, have a bathroom break if you need it. Again, for those who may have come in a little bit after I made the announcement, if you do need to use the restroom, they're located right outside these doors to your left, and we're going to get started. So I will not painfully introduce myself since I am your first presenter. My bio is in the materials if you are interested in reading it. And we're going to get into our first topic, which is language access nuts and bolts. Just a basic beginner, just to make sure that everyone is operating from the same page. Last year when we did this program, we focused the entire program more on being an introductory program regarding language access. And even though this year we are focusing more within the ethical and professional considerations, we still want to make sure that we just have some general foundations that are set so that we can make sure that we're all, as my grandma used to say, singing from the same page in the hymn book. So when we talk about language access, there's some principal authority out there that most of you are probably already aware if you work a lot with limited English proficient clients, which I'll refer to as LEP throughout our day-to-day, or individuals who are deaf or hard of hearing. Some folks refer to it as hearing impaired. I use deaf and hard of hearing because a few years ago, the deaf community and organizations, advocacy organizations, determined that hearing impaired was no longer, the preferred term within the deaf community. They believed that it had a negative connotation because it insinuated that if you were not able to hear, that was a quote-unquote lesser status. So you will see a lot of agencies and a lot of advocacy organizations in general now moving to the term of deaf or hard of hearing. The most principal authority is Title VI of the Civil Rights Act of 1964. And in a nutshell, what that says is that any recipient of federal funds has a legal obligation to provide meaningful access to its services at no cost. 10 years later, in 1974, the Supreme Court ruled involving Nichols that again, a recipient of federal funds cannot discriminate on the basis of national origin, which would include someone who is limited English proficient. We then, in 2000, even though we had the Civil Rights Act of 1964, and we had Lousy Nichols 10 years later, it really wasn't until August of 2000, when President Clinton signed Executive Order 13166, that we really had something with some teeth, some enforcement. And in that executive order, it didn't really raise anything new. It just reminded agencies that they had this duty under Title VI. But specifically here in Georgia, we have two benchmark cases that are really, really instructive. And so if you have not yet read them, or if you're in practice and you ever come across an issue or a challenge with having the court to provide an interpreter for you for any legal proceeding, and we're going to get to what I mean by legal proceeding in just a moment, because there seems to be a little bit of confusion as to what that means and who's applicable and that type of thing. But in Ramos v. Terry in 2005, the Supreme Court held that it is an abuse of discretion for a court to not appoint a qualified interpreter who is impartial and who will follow the interpreter code of professional conduct, the equivalent of what attorneys have. We have our code of professional conduct. And just a little bit of background on Ramos v. Terry. What happened there was a habeas proceeding, and the defendant was women English proficient, speaking only Spanish, and they had one sole witness. And so on the day that the sole witness was set to testify, the interpreter, the certified interpreter that they normally used, was not available. And so the court, not wanting to inconvenience and risk having to reschedule the case, asked for a prison guard to come in and interpret. And her qualifications to interpret were that she was present and she spoke Spanish. And the court did not ask her, and this is in the opinion, this is why in that particular case it was found to be an abuse of discretion. She was appointed without ever having been apprised of what her role as an interpreter would be, not having signed anything that she agreed to comply with the ethical standards that were required of her of an interpreter. The court noted that she was not asked if she had ever had any experience before interpreting in any other court proceedings, or at all for that matter. There was no inquiry made into whether her dialect of Spanish was compatible with the dialect of Spanish of the defendant, and just a lot of other inquiries that could have been made for the court to verify that she was qualified to interpret. And so that's one of the things that we just want to make sure when we are going forth and we are practicing, that we want to make sure that in the most friendly way possible, we just let the courts know that it really is important to have someone who is qualified to interpret, and mere bilingualism is not enough to serve as an interpreter. There are plenty of folks who are bilingual, but they are not competent to serve as an interpreter. Interpreting requires much high-level skill than just knowing the language. In 2010, we had another case, Ling v. State. And again, the facts there briefly was that there was a mother who was at risk of losing her children. The court determined on appeal that she had not been provided with adequate interpretive services at the trial court level, and that case was remanded. So it is very possible that if the court fails to provide a competent interpreter, that a case can be, that is a basis for appeal, and we'll talk about some of the more common bases in a few moments. But it can be appealed and possibly either reversed or remanded. The current policy of the state of Georgia is that LEP and DHH litigants and witnesses are entitled to qualified interpreters in court. And that right applies to all cases, criminal and civil, as well as administrative and alternative dispute resolution, or ADR, forms. The expense of providing the interpreter is borne by the local court or the agency. And so we do have here, and it does get a little bit hairy, because we have here in Georgia, and we're lucky to have it, a Supreme Court rule governing the use of interpreters for non-English speaking and the titles of hearing impaired persons. And so of course that governs all of our judiciary, and it's very clear, and it sets out the standard, and it talks about our licensing designations. And that rule was created by the Supreme Court of Georgia Commission on Interpreters, which was created in 2003, and that is the licensing and regulatory body for Georgia courts. In 2011, the rule was amended, and it came right after, if you notice, it was 2011. Ling was 2010. So a year later, the rule was amended so that it was clear that the right to an interpreter was applicable in the civil context, because there was still some confusion about whether or not courts had to provide and pay for an interpreter in a domestic violence case, in an eviction case, any type of civil matter that was there, and the answer is yes. The commission is available. We have, I know here, our program coordinator, Shinji Murakuma. She'll be speaking in a few moments. And in the staff, and also I think Linda may be here already, Linda Smith, but they are available to courts if there's ever a question, or if they believe the commission can be of service in either helping to find an interpreter, especially in a language that may not be on the statewide registry, and to provide other services as well. And so I went over that LEP. One thing that I also wanted to make sure we highlight, a lot of times we hear interpreter and translator used interchangeably, and they're actually not. They actually do have two distinct differences. And so when we speak about interpretation, we're talking about the oral communication, or oral communication that is rendered from one language to another. That original language we refer to as the source language, and the language that it's going into is the target language. And so individuals who are performing the rendering of those oral communications, that is who we refer to as interpreters. Conversely, a translator is someone who is rendering written text. And so that is especially for when you have a document, if you have a letter, for example, say you have a birth certificate that is in French, and you need that birth certificate to then be conveyed into English. So that birth certificate would be translated. But if you had a French-speaking client, then you would want an interpreter who could interpret for that client or for you in court or in a meeting. So here in Georgia, with regards to the appointment of interpreters, and I'm going to talk about it in terms of sign language and foreign language, or verbal language is when I refer to foreign. In order to be in order to work here as a sign language interpreter in Georgia, you either have to be court qualified or qualified. And to be recognized as such, the interpreter has to hold a current certification from RID, which is the national accreditation body, the Registry of Interpreters for the Deaf. And here in the Georgia Code, you can actually find all of the regulations for here in Georgia at OCGA 24-6, 652 through 658. And it lays out there who is responsible for paying for an interpreter for someone who's deaf and hard of hearing. It talks about the recording, if there needs to be any type of audio-visual or audio recording of any testimony that is given, and it gives all of that. And so that's a really great resource if you work a lot with deaf hard of hearing litigants or witnesses. Now, when we get to foreign language interpreters, how many folks in here have had to work with an interpreter before for a case? Raise your hand. Okay. How many folks do we have in here who are bilingual? Okay. When we are speaking about foreign language interpreters, a lot of times, especially if you're more familiar and you've had to work with them, you'll say, okay, I think I know I need a certified interpreter. And another thing that I want to share with you all today, the commission, we have 3 licensing designations, and it's important to understand those licensing designations because they go directly to the skill level of the interpreter. And so first, and the first preference are our certified interpreters. And a person is certified after successfully completing an oral and written exam, and they must earn at least 70% on each component of the exam. We currently have about 98 certified interpreters. The number changes as we recently had some test results to come in. And those languages are Spanish, Portuguese, Haitian Creole, and Mandarin. And as you all can imagine, the majority of those interpreters are here in the Atlanta metro area. But Georgia has 159 counties, many of which, once you get out of the metro area, are rural. And so it's very difficult for 98 interpreters to be able to spread out. So we do have a need. We definitely do have a need. But the Supreme Court rule is very clear that the court is required to make a diligent effort to first appoint an interpreter from the certified category. If no certified interpreter is available, because it happens, then the next designation is what we call conditionally approved. And that is someone who has achieved an overall score of 60 on the oral and written exams with no single score below 50%. We currently have approximately 44 conditionally approved interpreters in Cantonese, Korean, Mandarin, Portuguese, Spanish, and Vietnamese. But as you all can see from the slide, we have 1 Cantonese, we have 1 person who is conditionally approved for Korean and in other languages, but we have very significant populations that speak that language, and so again, we do have a deficit and are in need of more qualified individuals for testing. The rule, when you look at Appendix B, Section 2B, states that it is intended that a court will only appoint from the conditionally approved list if a certified interpreter is not available. And our last category is registered, and that is specifically for languages in which there currently is not a national certification exam. So if you ever see someone who says that they are a registered Spanish interpreter, that's a red flag, because there is no registered Spanish interpreter in Georgia. They can only be conditionally approved or certified, or any of the other language for which we do have a certification exam. Currently, our registered interpreters speak languages of Amharic, Bosnian, Croatian, Farsi, Persian, Serbian, and Urdu. And it again is intended that the court only choose from this list if no certified or conditionally interpreter is available. And now we know sometimes, and I always like to point this out, and the rule is very clear, and I'll read it because I don't want to paraphrase. The rule talks about, because the rule understands that sometimes there just may not be a licensed interpreter available. And so what happens, how should the court proceed? What should the attorney do? And so when faced with that need where no licensed interpreter is available locally, courts should weigh the need for immediacy in conducting the hearing against the potential compromise of due process or the potential of substantive injustice if interpreting is inadequate. So unless it's really, really necessary, we really want to look at whether or not we should continue the case until a competent and qualified interpreter is available. If for some reason you do need an interpreter, there is a statewide online registry if you go to the Commission's website, which categorizes our interpreters within their licensing designations, by language, and by county. And so you can see, because a lot of times interpreters charge if they have to travel, part of their expense is for travel. So you do want to try and have the court appoint someone, and courts try and appoint someone who is as close as possible to minimize the expense. But if for some reason there is a language that is needed for which we have no licensed interpreter, courts are encouraged to contact Commission staff who can possibly, oftentimes will assist with trying to find a qualified individual in the language needed. Alternatively, I know sometimes it is necessary to contact reputable commercial interpretation or translation services. And if you look in the outline that was provided in your materials, there is a resources section there that names a few. And those aren't necessarily an endorsement, but those are just some that the Commission has used in the past, and others that practitioners have shared with me that they have used, and so that may be of help to you. You'll hear a little bit more about this, so I'm not going to spend a lot of time on this. National Center for State Court National Registry. That is an initiative that is going on currently at the national level to develop a national registry of interpreters that courts across the country will be able to share resources with one another. And Tina Vagenis, who is the Chief Counsel for Access to Justice Initiatives for NCSC, is going to talk with us in more detail about that a little later. So I said a little bit earlier, is it reversible error? What happens when, in a case, an interpreter is needed and the court refuses to appoint one or proceeds without one anyway? And the answer is yes. Failing to secure a qualified interpreter can result in reversible error on appeal. According to the National Association of Judicial Interpreters and Translators, or NAJIT for short, the primary interpreter issues on appeal are: 1, failure to appoint an interpreter; ineffective assistance of counsel; bias and conflict of interest; confidentiality; appointment of uncertified interpreters, including bilingual attorneys serving as interpreters. And we'll talk about that because a lot of times that happens. The court sometimes thinks, oh, well, you're an officer of the court, you're bilingual, you can interpret for your client and also be an effective advocate at the same time. Or better yet, we'll let you interpret for the opposing party. But that raises a little bit of conflict of interest, as I'm sure you can imagine. And it's difficult not only because, one, oftentimes that bilingual attorney is not licensed to interpret, but 2, it is physically impossible to do that, to be a zealous advocate for your client and then focus on being able to provide accurate and competent interpretation. Lastly, borrowed interpreters, similar to what happened in Ramos, getting someone who's not qualified, maybe another employee or someone to come in, having the bailiff to serve as the interpreter, or as Bernadette shared with me when I first met her, one of the judges saying in the middle of the court hearing, oh, someone run down to the Mexican restaurant and get somebody. We can't have that. And also, the last thing, accuracy of interpretation. So these are the primary issues that we frequently see on appeal. Specifically here in Georgia, we talked about this, I talked about this earlier, Ramos v. Terry. And I also wanted to highlight something else with interpreters, and this goes specifically into the ethics portion. Interpreters and attorneys, their roles are largely antithetical. An attorney has an ethical obligation, he or she has an ethical obligation to competently represent their client, and that includes having effective communication with the client. And in order to have effective communication with that client, you need to frequently be in communication before, during, and until the case is over with. Conversely, interpreters, they have an ethical duty here in Georgia to avoid undue contact with the court and parties before, during, and until the case concludes. So that's just a prime example, which I think is very easy to see, that you cannot be the interpreter and the attorney because you're going to violate one of those codes of conduct. And so that's why it's very important that we have roles for, make sure we either have on one hat or the other, and that if you are wearing the role of the hat of interpreter, that you are licensed to do so, or competent to do so. And again, this is the language from Ramos here when they talked about it. And I just want to know, if you look here, that third bullet, it says it's an abuse of discretion to appoint someone to serve as interpreter who is neither certified nor registered. And I want to just highlight that came before we had the conditionally approved category. So now that would include that category as well. So what happens? Can't get anybody who is licensed. Again, if after a diligent search, no certified, no conditionally approved, no registered, what do? If the court determines that a use of a non-licensed interpreter is warranted, they are encouraged to look at COI, or the Commission's instructions for use on a non-licensed interpreter, and that is included with the materials. I believe it's in your core materials there. However, at the end of that proceeding, the court should make a diligent effort to secure a certified or other licensed interpreter for any future legal proceedings regarding that case. And so as practitioners, for those of you who are practitioners, I would encourage you to make a motion on the record so that it is preserved, so the court can't say, oh, we didn't know. Go ahead and put it in on the record. I move that a certified or other licensed interpreter be appointed for any future legal proceedings. And I always like to say it's preferable to do that in writing. If you know up front that you may be in a judicial circuit or a court where there are challenges with getting interpreters appointed, then you can look at the sample pleadings that are in your supplemental materials online. Georgia Legal Services has a brief and sample motions that you can look and use to help filing in your cases. A reminder with the use of non-licensed interpreters. Being bilingual does not qualify one to serve as an interpreter. Children should never be used to interpret. How many folks have seen children interpret in some capacity or another at some time? Totally inappropriate and totally in contradiction to Georgia's policy on interpreters. In order to be a licensed interpreter in Georgia, one of the criteria is that you must be at least 18 years of age or older. So we want to make sure that children are not being used to interpret, and that is an exception and not a rule, and we really want to stay away from that. Again, it is inappropriate for bilingual attorneys, relatives, or friends of the LEP or DHH litigant or witness, bilingual judges, courthouse staff to interpret in the legal proceeding. And I will refer you to the Administrative Office of the Courts working with foreign language interpreters in the courtroom brochure. And I see them going down, so I want to make sure we get to it. A lot of times you go, well, how do I let the court know that I need an interpreter? One of the challenges that Georgia faces is that we have a non-unified court system. So unfortunately, we don't have a uniform protocol for appointing interpreters in our judicial districts across the state. So the protocol is going to vary. In some judicial districts, you can simply make a verbal or written request to the judge's law clerk or administrative assistant, and that is who handles the request. In others, you may make a verbal or written request to the district court administrator. There may be a specified point person within the judicial district, or you may go through the clerk's office. So I would first start with calling the legal secretary or the administrative assistant of the judge and ask if you know, when you know that you're going to need an interpreter, that you go ahead and put the court on notice and ask, what is the protocol for this circuit? Now they may say, I don't know, and you may want to look, but these are at least the 4 individuals that you can check, because it should be one of these 4 individuals wherever you are practicing. Once the request is made, usually judges will go ahead, a lot of times in my experience, and appoint the interpreter just based on counsel's request or the pro se litigant's request, but the judge may voir dire the person to determine if they believe that an interpreter is truly needed. And we want to make sure that that judge is using active vocabulary, asking general questions and also questions about the proceeding. And we want to avoid, and these are sample questions that come directly from the rule, and as you notice, they're phrased in a way to avoid eliciting simple yes or no answers, because we really can't assess someone's comprehension if they're just answering yes or no. The fact that someone speaks some English or understands some English does not preclude them from being entitled to an interpreter. And in some instances, as I mentioned, the decision maker can skip the voir dire process. When we talk about recording interpreter testimony, and you can read it there, but I'll summarize it in the interest of time. If a certified interpreter is not used, the Supreme Court rule does require that there is an audio-visual or visual recording of any non-English testimonial statements. So that means if the interpreter is conditionally approved, if they are registered or simply non-licensed, then there should be an audio-visual or visual recording of the non-English testimony. However, if it is a certified interpreter, then the record will just reflect all of the English testimonial statements, which would be whatever the interpretation is from the interpreter. With regards to sign language, that can be found in 24-6-657. That gives the rules regarding interpreting, and those are your resources there that you will see outlined in your materials. Okay, I can read. That was a lot. I want to make sure we stay on time. Any questions? We're going to answer a few questions. Are there any questions? Comments? Okay, y'all are easy. I was just, you messed me up. No, I'm just kidding. There you go, yes.
What if you're not the attorney on the case and you're bilingual? Could you interpret for the court? Is there a waiver that the client would have to make in order for you to interpret?
If you're not the attorney? Okay. So the question was, what if you are not the attorney on the case and you're bilingual, can you interpret them? The answer would be that would not be encouraged, because you want to look, are you licensed to interpret? If you are not a licensed interpreter, then the court really shouldn't be appointing you unless it's really just an emergent situation and they can't continue it. There has been a situation, again, and I've seen this with judicial districts, where there is a local attorney who is well known to be bilingual, and so the court will just call that person in. But that really is an inappropriate practice. The court really needs to make a diligent effort to first appoint someone who is certified or otherwise licensed. And again, there will be emergencies that come up, and they will have to use a non-licensed interpreter. And so in that instance, may they use an attorney? They may. And is that automatically going to be reversible error? Possibly not, if they can show that we didn't have any choice and we really needed to have that hearing today. Yes, ma'am.
I practice domestic law, and sometimes we're ordered to go to mediation. If you're ordered to go to mediation, is the court required to provide you with an interpreter?
I'm so glad you asked that question. Yes. If you look in your materials, there is a handout that says quick facts regarding interpreters in ADR and administrative forms. And that gives a lot of information on that very question. But the quick and dirty answer is yes. For all, there is required to be a court-appointed interpreter in all court-managed functions, including alternative dispute resolution. There was recently an inquiry about, well, what if I'm with, a state agency? We don't fall under the Judicial Supreme Court rule. And that is true. So we can't be bound, to make that agency comply with the rule, because there's a separation of powers issue there. However, that state agency is more than likely than not receiving federal funds, and so they are bound and must comply with Title VI, which requires them to provide interpreters in all operations of their agency. So if they have any type of administrative process, an interpreter must be provided under Title VI. If you are going into court, any one of the Georgia courts, they're bound by Title VI, as well as the Supreme Court rule that says that an interpreter should be provided at no cost for the arbitration or the mediation. Yes, sir.
There are any law enforcement doing certified when they go first responder, they go to the scene, because that's really important.
Yes, and I don't want to make sure we go over, but the question was about law enforcement, and that is an area. Law enforcement is required under Title VI to provide certified or qualified interpreters, rather. And that's something that we'll be talking about in another another context. But yes, when they are responding to a call, and it does happen, and again, it's hard because it's how practical is it, you know, if you're getting called out to a domestic violence call at 4 o'clock in the morning to maybe have to wait on an interpreter, and it's really tempting if the child who's there or the abuser speaks, you know, English, and oftentimes they will try and communicate, and it is a challenge, but the law enforcement agencies should have in place a plan generally for being able to provide services to those. Well, I will stay after. I want to make sure we stay on time for our next guest, but I will be here all day. You can catch me. I'll be here for lunch if anyone else has questions. My email and information is in the bio, so feel free to ask any questions that way, and I thank you guys. So our next speaker is Michelle West, who is the director of the State Bar of Georgia's Transition into Law Practice program. Many of you, if you all will remember having to go through those requirements when you were first barred. Georgia didn't just send you out there as soon as you get a bar number, but there are some requirements first that you must fulfill before you can appear as lead counsel or solo counsel in a case. And I won't go through Michelle's whole bio because it's way too impressive and long, but if you read it, it is in the materials. And so without further ado, Michelle West is going to present to you on professionalism considerations within the context of unpaid access.
Good morning. I'm talking so loud, I don't even need the microphone. Good morning. Good morning. Okay, you guys can do better than that. Good morning.
Good morning.
Thank you for being here today. As Jana said, my name is Michelle West, and I'm the director for the Transition into Law Practice program at the State Bar of Georgia. I am also, prior to taking my position at the State Bar of Georgia, I guess you could say I'm a recovering family attorney. I had a general practice where I focused a lot on family, immigration, real estate, and estate planning. So I come to you today having worked a lot with clients that have limited English proficiency, and however, I have not worked with any clients that have a hearing impairment. I am also a member of the State Bar Committee on Professionalism and the Chief Justice Commission on Professionalism. So basically what we have here is the Chief Justice on Professionalism mission. And basically this is the mission. You know, we have ethics and we have professionalism, but this is kind of the permission or the aspirational goals that they would like us to embody as advocates of the law. So they want us to support and encourage lawyers to exercise the highest level of professional integrity in their relationships with their clients, other lawyers, the courts, and the public, and to fulfill their obligations to improve the law and the legal system and to ensure access to that system. So that's a lofty goal, but I know that through our education and then through our basic values that we can actually accomplish this. Let's talk about ethics and professionalism. Ethics, they're mandatory regulations, and professionalism are just aspirational ideas. So there's a professional mandate for us to actually abide by the professional rules of conduct. And for professionalism, it's a personal mandate. For professionalism, we are guided by the aspirational ideas and a lawyer's creed. For ethics, when we need guidance, we turn to rules and we turn to the ethics hotline. And I put the number up there so in case you ever have any question regarding ethics on a matter, then you can contact the ethics hotline at the State Bar and they should be able to assist you. You can also send your inquiry through the web. And to guide us as far as professionalism is more of a moral compass. And again, it's the aspirational ideas and the lawyer's creed. Ethics, whenever we violate an ethical rule of conduct, then we're disciplined or we're sanctioned. And then professionalism, it affects our reputation and at many times our credibility. Some general aspirational ideals that are on point for us today is about basically including everyone in our advocacy and making sure that everyone can access justice. And these are some of the general aspirational ideals that I pulled from the Chief Justice Commission on Professionalism ideals. The second thing is a lawyer's creed. And basically to our clients, this is what we want to offer: faithfulness, competence, diligence, and good judgment. To the courts, we want to assist them and we want to offer respect, candor, and courtesy. And to the public, we want to offer service, we want to strive to improve the law and the legal system. Again, we want to make the legal system available to all, and we want to seek the common good. Now, if we're trying to do all that, right, we have rules of conduct, we have aspirations. How do we get to this? This was the comment of a New Jersey judge once a defense lawyer walked into court and said that his client had violated his probation. And he stated, not only do we have to let him come into this country illegally and stay here, not only do we have to provide him with public assistance, not only do we have to provide him with free health care, not only do we have to provide him with a free attorney when he gets in trouble. Now he wants a bilingual probation officer because otherwise it's convenient for him. So how do we get here? We get here because we have IQ, we have intelligence, we have emotional intelligence, we have EQ, but a lot of times we lack cultural intelligence. This is a quadrant of how David Livermore, who's supposed to be the guru of cultural intelligence, and he breaks it down into 4 quadrants as to what we need to strive for. We need to have the drive, right? We need to have the drive to go out and to seek justice for our clients. We need to have the knowledge. We need to learn the micro and macro differences between cultures. We need strategy. We must plan how to navigate these differences. And we also need to take action. We need to be able to take action and have confidence to cross the cultural divide. And in your practice, this means developing an overall sensitivity to world cultures, asking questions that may not be the norm concerning values, systems, and beliefs of your client. we would like to get to cultural competency. Cultural competency is more than embracing diversity and promoting inclusion. It is the ability to adapt, work, and manage successfully in new and unfamiliar settings. So this is what we're striving for when we're working with clients today, with the changing demographics. Being culturally competent means having the ability to grasp, reason, and behave effectively when faced with different cultures. We want to recognize how culture impacts perception and behavior. And we want to place apparent contradiction in cultural context and deal with any ambiguity. And this is what we're doing when we're dealing with limited English proficient clients and deaf and hard of hearing clients. So, what I did is, in order to make this a little interesting for you, I didn't want to stand up here and talk the entire time, because then I get all hot and, that's just kind of what happens with me. So what I did is I decided to actually go and talk to some stakeholders and talk to lawyers who are actually who's actually out there and representing clients. And so when I went to talk, I talked with 5 lawyers, and I will present the videos in a minute, but these are some questions that I posed to them. I asked them, what has been your experience in assisting LEP and DHH clients in accessing justice and navigating the legal system? How has assisting LEP and DHH clients impacted your professionalism? A sampling of the attorneys that I spoke with are Sophia Byers. She's 8 years in practice. She practices immigration, family and estate planning. And she practiced in immigration and civil court. So what I tried to do is get people of varying years of practice, varying practice areas, and then who practice in different courts. So we have Sophia, Patricia, Park, Kristen, and Jose Feliz. In addition to these attorneys, I was able to talk with one judge. And the question I posed to her was, what have you observed while presiding over matters involving LEP and DHH litigants as far as their ability to access justice and navigate the legal system? And how have you seen professionalism impacted in the matters you have presided over where there are LEP and DHH litigants? The judge that I spoke with is Pam South, and she is 15 years on the bench, and she's at the Gwinnett County State Court. And before that, she was a prosecutor, and she also did some civil work in private practice. Oh, I have a disclaimer. I am no documentary filmmaker. That's my first one, okay? My second disclaimer is, at times, you will think I have limited English proficiency, okay? I start like mixing proficiency and proficient. And so the third thing is, I am also no Hollywood movie editor. So I wasn't able to edit that out. So we're gonna roll with this, but what I want you to do is basically listen to what they have to offer and what their experience is. So that's basically what I want you to focus on. And then when I say stuff, just cringe and move on, okay? So let's get started.
My name is Jose Velez, and I am a solo practitioner. The name of my practice is Velez Law Firm PC, and I have been practicing since 2004, but I have been on my own since 2010. My relationship with non-English speaking clients has evolved over the years. When I started, I had very few non-English speaking clients, and I was practicing under a senior workers' comp attorney for 2 years and did very little work with non-English speaking people. I left that and went to another firm and did homeowner closings. This was my first real experience with non-English speaking clients, and I began to do closings in Spanish, and had a lot of Hispanic people come to the firm to do their homeowner closings. What I began to realize was that a lot of these people had not been explained their contracts, did not realize that they were going to do balloons on the loans, and things like that. And that is when it first dawned on me that these people that did not speak English and did not understand the language well also were at a fairly substantial disadvantage in terms of understanding documents that they were signing and transacting business and things like that. That's planted a seed, and unfortunately the housing market fell, and I had to close 2 offices because I had actually grown to 2 different offices, and I had to close both those offices and moved to Atlanta and began doing workers' comp. But the seed had been planted to represent non-English speaking people because there was a need there. I worked for 2 years for another senior workers' comp lawyer, and then I opened up my own practice. When I opened up my own practice, I did some immigration work, and that opened my eyes further. In 2010, I started practicing by myself, and I can honestly say that my niche right now is representing non-English speaking people and helping them access justice in the legal field. My practice areas now are workers' comp, personal injury, and Social Security, and I focus almost entirely on non-English speaking clients.
Thank you for that, Jose. But I would like to ask you, in your practice, what has been your experience currently in the past and currently in assisting limited English proficiency clients in accessing justice and navigating the legal system?
All right. Let's go with currently, because that's where I'm at right now.
Okay.
And in the past, it was an evolution of realizing the need and then deciding that that's what I wanted to do. Currently, what I see is in workers' comp, cultural issues play out throughout the case. People are timid in terms of actually making claims. They don't realize that even if they're here illegally, that they have rights under workers' comp. And so a lot of the cases that I get have already started badly. There's notice issues, late reporting, and things like that. So there is a need. People that do not speak English and do not understand the system are at a huge disadvantage in accessing justice. They're taken advantage of. They are minimized in terms of what they're offered, and they don't know, and they don't even realize that they are being dealt with, in the manner that they're being dealt with. So my job and my niche and my desire, my goal in providing legal services is to help these people gain justice. There is a huge need. Their language barrier does absolutely impact their ability to access justice, and that has become the area and the way that I want to practice my law.
And how has assisting limited English proficiency clients impacted your level of professionalism?
And it has done that. I don't look at these people as coming to me on equal footing. So what that's meant to me is that I have to go above and beyond what I feel like is fair. If I was talking to an English-speaking person and I was explaining certain things to them, I would assume that they had been raised in this country, that they understood the concept of individual rights, things like that, and I would deal with them based on that assumption. I can't do that. There are cultural differences that would require me to look at people closer, understand where they come from, to understand what those cultural differences are and how they will impact that person and me transacting and conducting a case and a claim. So it has impacted my professionalism. It's caused me to go extra steps to do that.
Thank you so much, Mr. Velez, and thanks for being a part of the presentation.
Thank you. Thank you. My name is Jose Velez, and
The next person we will hear from is Un Park. She has a practice in Gwinnett County, in Duluth, Georgia, and she does mostly bankruptcy, personal injury, and real estate. I picked Gwinnett. I picked a couple of practitioners from Gwinnett because I don't know if you guys are aware, but Gwinnett, according to statistics about 2 years ago, is neck and neck with the county in Texas as being the most diverse county in the nation. And so I thought it was only fitting to actually try to get some people who are practicing in Gwinnett. So she will tell you about her experience in practicing in bankruptcy court and dealing with clients as far as bankruptcy, immigration, and personal injury.
Practicing law for 10 years now, and I practice in real estate business, bankruptcy, personal injury, and immigration.
Thank you, Ms. Parker. Great speaking today. I'd like to thank you for welcoming the presentation regarding the intersection between language access and professional making. My first question to you is, what has been your experience in the past and currently in assisting limited English proficiency clients in accessing justice or navigating the legal system?
Because most of my clients are Korean Americans, and because I do speak and read and write in Korean, and have the Korean proficiency, that I could help my clients greatly in local and access justice. Servicing clients with bankruptcy court for hearings. The bankruptcy court does provide a translator, but oftentimes the translation is done wrong. And because of my proficiency in Korean, I can catch that and can make sure that my clients does have the just access to justice by correcting the translator and making sure that trustees get the right information. Same is with the immigration interviews. Oftentimes when I go to the interview, I do ask my clients to bring the certified translators, but because of the cost, they may just want to bring friend or family who does not have the professional qualities providing the service, translation service. So when they do make a mistake or when translating the right way, I can definitely check that and make sure that the officers get the right information and answers to those questions.
Thank you. Can you speak a little bit about how assisting limited English proficiency clients impacted your professionalism? Do you think that you have to have a more heightened professionalism, more enhanced professionalism? How specifically or directly does assisting limited English proficiency clients impact your professionalism?
I do believe that you do have to have a heightened sense of professionalism because you really have to care for your clients to really provide just pretty much everything, every little services that others may not, translation services. When I do bankruptcy finance, I ask my clients to bring me the information, and oftentimes they don't even know where to get the information. They say that they must prefer anything in English. So any letters in English, they would just do it, and they would actually throw it in a box and bring the whole box to me, and I have to sort through and make sure that we have every creditor's information, and it's really tedious, and it's really not an offensive job to do that, but because because we have to advocate for their rights. I don't mind spending hours trying to figure out what those documents are and organizing them and putting them into the case for my clients. So yes, definitely we do have to have enhanced sense of professionalism in order to assist clients with legal or English proficiency.
Thank you. I really appreciate you taking the time out today to speak with me. And I just want to say thank you. So what are some current trends what are some common themes that you're seeing that these attorneys are having when dealing with clients who speak very little English? Have you noticed just by what they've said so far, what Catherine and Jose has said so far, like what are they finding when assisting such clients?
Just the document interpretation, that
Yeah.
bothers me.
And why does that bother you?
Why isn't it in their native language?
Well, I think what she's referencing is if they come to file a bankruptcy, they need to get specific documents. Well, a lot of times, it's not even just navigating the legal system. It's actually navigating the banks, navigating, dealing with trying to get mortgage information. And if you don't speak the language and you don't really understand the system, not only do you have that legal hurdle, but you have the hurdle in just accessing information in general. So so sometimes when dealing with such clients, instead of having the calls constantly, like, what is this? I found this, what is this? Or sending in piecemeal information, what you tend to do is you go above and beyond. You actually get the box of documents and you go through them, or you have your paralegal go through them in order to actually get the necessary, what's necessary. And then with that time and finding that documentation, you can't bill them for all of that time, or you could, but trying to be an advocate and understanding their situation, it's very difficult to bill for all the time that it's actually taking you to do that. Is there anyone else? Okay, so we're going to hear from Patricia McKenzie. She's been practicing for about 7.5 years, and again, she's in Gwinnett County. She's going to talk to you a little bit about representing a hearing impaired client. And there was a client and the victim who were both hearing impaired, and she's going to talk a little bit about her hearing. She also does immigration and some criminal work.
I'm Patricia McKenzie. I'm an attorney practicing here in Lawrenceville, Georgia. I've been practicing for approximately 7.5 years, and I practice primarily in immigration and family law, some representation.
Well, Patricia, thank you so much for actually taking time to speak with me today. As I told you before, I'm working on a presentation as far as the intersection between language access and professionalism. And the first thing I wanted to ask you was, what has been your experience in assisting limited English proficiency and American hard of hearing clients in accessing justice and navigating the legal system?
Well, in immigration court, the clients there always receive language access. Most of the clients speak Spanish, and there's always a Spanish interpreter whenever there's someone on the docket for that day that speaks Spanish. Most of my clients are Spanish speaking, and maybe 75% of my clients are Spanish speaking, and another 15% will be English and mixed. And if those clients are going to immigration court, they'll always have access to either the language line or an interpreter will be requested for their hearing. So that's never a problem. The challenge is in civil court, family law cases. Most of the time, civil litigants are not automatically granted an interpreter for their hearing. And so sometimes, and depending on the court, you can request an interpreter be present, and we do have to give them a considerable amount of notice. And sometimes they'll also be required to pay for the services. Most of the time for my cases, my bilingual assistant will accompany us to court assist us there, and that's if the judge allows it. Often, however, the cases will be continued if an interpreter is not available. Sometimes, some courts will allow a continuance, and that can really cause a problem. So I usually make sure that my assistant is available when my clients are going for family law or for other civil cases. In criminal court, a defendant is always provided with an interpreter in historical language. And if it's a language other than Spanish, then one is usually requested for that defendant. And it's never really a problem for Spanish clients. However, I have had an experience where I represented a deaf and hard of hearing defendant in criminal court in DeKalb County, and the victim was also deaf and hard of hearing. Both were classmates, and the court continued the case a couple of times to ensure that we had the correct interpreter, and we needed 2 sign language interpreters, one to interpret for the court, and one to interpret for my client, and one to interpret for the victim, and then also a certified deaf interpreter, which was an additional layer needed for my client because his sign language is not precise American Sign Language. And so that was a very interesting hearing. Judge Adams of the DeKalb County was very accommodating, and that was one of the main experiences I've had that where language was a barrier and the court was very accommodating and ensuring that everyone understood what was happening and what the consequences were and what the law was as well. So that's kind of my experience when it comes to Spanish language.
And how is dealing with women that need proficiency and deaf and hard of hearing clients impacted your professionalism, your level of professionalism?
Well, I would say that it's definitely enhanced my level of professionalism and challenged it at times because it's not just language, it's just communication in general because even though you may communicate something in Spanish through an interpreter, culturally, the person receiving that information may still interpret it a different way. So it's necessary to explain it in multiple ways and to explain the consequences, the reasons to that particular client. So it's definitely forced me to be a better attorney as far as communicating with my client. And a lot of times with these clients, you have to take into perspective or take into account their cultural perspective when it relates to our justice system, because our justice system is very unique. And so a lot of times we communicate that and try to understand where they're coming from and understand that sometimes they're coming from countries that don't have a sophisticated justice system like we do, and explain that, explain how it works, and explain why. Certain things may not be possible or why they have to do certain things. So it's definitely caused me to be more careful and to be more diligent about how I communicate with different forms of communication that I'm employing in my practice.
Well, thank you so much for coming. We appreciate you taking the time. Have a great day. So is there anything that Patricia talked about that resonated with you in the audience? Go ahead.
I'm a certified Spanish interpreter working in DeKalb County courts. I think it's really important, your session is very important because of the nature of the concept of professionalism. Obviously, we're looking at how you can be a better advocate for your clients. On the other hand, one of the things that can add to your professionalism is not just identifying whether you need an interpreter, how you can get that interpreter, and whether it'll be available when and if you need it, but actually knowing how to work with that interpreter. It's very easy to say, oh, that's a bad interpreter, or that interpreter wasn't doing what that interpreter needed to do. But On the other hand, you have to look at, are you asking the interpreter to do things that are beyond their scope of practice? Are you working with an interpreter in a way that that interpreter can get out of the way of the communication and just serve as a conduit? So there are lots of things that we can do, and as a matter of fact, I'll just say that interpreters love working with attorneys who know how to work with interpreters. You will get the absolute best communication and the best result if you have familiarized yourself with the scope of work of the interpreter and everything across the board, including your dealings with the court, hearings in front of judges, dealing with documents. All of those things will go far more smoothly and will enhance your professionalism if you have become aware of how to work side by side with the interpreter and use their skills.
Now, let's talk about questions. So if we are in the middle of trial and we have an interpreter and we're asking questions to our client, a lot of times when you represent, because about 50% of my practice were English-speaking clients, and other 50% had limited English proficiency. So is there a certain way that you want us to ask you the questions so that they're maybe not compound questions but are more direct questions? Could you speak a little bit, tell us a little bit about that?
Sure. Are you speaking of when a person is at the witness stand and they?
Yes.
Absolutely. First of all, compound questions are complicated because you might be asking the question, which is, where was she when she or he was, who was in the kitchen with whom? You have to be very specific about where was Mr. Lopez when Mr. Jones walked in the door. The he and the she are very confusing because in Spanish and in other languages it just confuses the whole issue. Questions that end with, isn't it so, such and such and such, or isn't it true that, you might get an answer that's a no or a yes, which is completely opposite to what you are actually looking for. The interpreter could potentially ask the question in that same exact way and receive a completely different answer than what you're actually asking them. So really, the question should be as simple as possible. It should be as straightforward as possible. It should communicate to the person who you are actually talking about if you're asking for a description. And my recommendation to attorneys and even to judges is wait, pause for a moment. I love these attorneys who will go, so you're saying, I love that because that has given the interpreter the opportunity to finish their interpretation. It has given the person the opportunity to actually consider the interpretation, and it has given everybody an opportunity to listen to what has been said. I think one of the biggest problems, in addition to complex questions, is when an attorney is asking one question right after another, just yes, no, and not giving the interpreter a chance to really get the point across, and there being some space for actually people to listen and absorb what's being said.
Thank you for your comment. What's your name?
Maria Ceballos.
And I think what Maria is pointing out is when we're dealing with professionalism, it's not just communicating with our client, right? It's also communicating with the interpreter so that we have the ability to properly advocate and to effectively assist them.
Jackie Downs, interpreter. Just two quick points that I've noticed very often. Attorneys telling their client or the defendant, or they tell the interpreter, tell him or her. Okay. The attorney needs to direct themselves and look at the person, the LEP. Look at them in the eye as they're talking to them. They don't need to look at the interpreter. And go ahead and just talk to them normally, and we will interpret properly.
Thank you. Have one more?
I have had hard of hearing clients, and when one client did not completely understand American Sign Language, that was interesting that she said they had to have so many interpreters for that community because oftentimes, someone has taken interpreter I had didn't really understand completely what they were saying. So sometimes we do have to get interpreters for people that are deaf that may have more experience, you know, with the deaf community, because every day communicating with people that don't have the highest education.
Okay, the next person that we're going to hear from is Kristen Gladhill Williams. She practiced solely immigration law. She is a Spanish speaker, and the majority of her clients are Spanish speaking. And she practiced the majority of her time solely in immigration court.
Okay, hi, my name is Attorney Kristen Gladhill Williams. I have been a Georgia lawyer since 2008. I have always practiced in the area of immigration law, and that is the exclusive area that I practice in. I'm here today. I've been asked to speak first about what observations I've had over the last 7 or 8 years in regards to limited English proficiency clients, and how has their limited language skills impeded their access to law and justice in the United States. And I have a few comments about that. Primarily, I'm dealing with Hispanic clients in this office, so I get clients from all over the world, but mostly Latin and Central America and Mexico. Very few of them have a high level of English proficiency. I fortunately am bilingual and do speak Spanish very, very well, so I am able to communicate with them. However, one of the first thoughts that I've had on this issue is one of the things that I see frequently are prior criminal convictions for a lot of these clients. And when I start talking to them about it, and I get down to the nitty-gritty of sort of, well, what happened? You know, what happened in court? Did you have an attorney? I'm always amazed by the large percentage of clients who were not represented by counsel during their criminal hearings. Instead, they relied on the court interpreter to help them through those hearings, and in fact, to basically give them legal advice. A lot of those people are told by the DAs or the prosecutors or the solicitors through the interpreter that, you know, they should plead guilty to this so that they can get out of jail and just go home, that that's the only option for them. You know, they're never told about the option to have an attorney, except probably in passing by the judge, because that's just part of the transcript, but they don't truly grasp that. They don't truly understand that when they are pleading guilty to these things, it stays on their record, okay? You know, and a lot of times they'll just be like, okay, I'm just going to plead guilty to this because that's what they're telling me to do, just so I can go home to my family, just so I can get out of here and be done with it. They don't realize that when a criminal case is open, that's the time to fight it. They don't realize until it's too late. In other words, until they come into my office 10 years later and now we have a bar, right? Because we have that prior criminal conviction. In terms of getting those cases reopened, it's exceedingly difficult to do. Most of them have passed already their habeas appeals rights. You know, whatever appellate rights they might have had are long since expired. And it's always a very big shock to these clients. The second thing that they tell me frequently is, oh, no, yeah, I went to court for this before, but I'm clean now. I did everything. I paid my fine. I paid my community service. I completed the probationary terms that they gave to me, or I did my jail time. I'm clean. They think that their record is literally clean because they, you know, complied with the punishment that the judge gave to them. They don't understand that a guilty plea or a guilty conviction is always a guilty conviction, especially for purposes of immigration. They think that once they've completed those terms that it's somehow gone off their record after all of these years, and that's an exceedingly big shock to these clients. I would say that it is directly related to their lack of English skills. They just don't understand what's going on in court. Again, their only lifeline a lot of times in these courts is this interpreter who's not an attorney. The interpreter's job is to simply interpret what the opposing counsel is saying to the client. And of course, it behooves the solicitor or the DA or whoever, the government attorney, to convince this person to take a guilty plea, because that's their job, right? So I see this just a lot, and to me that is a very big problem. And it's one that cannot always be remedied. It oftentimes does permanent damage to their immigration cases, which is really unfortunate. So that's probably one of the biggest observations that I have about it. In terms of the immigration court, which is where I appear on a regular basis, there is always a Spanish interpreter. However, and most of, again, my clients are Hispanic as well, so, you know, I am able to communicate to them, I think, fairly well what's going on, and they, generally speaking, will understand what's happening in court because there's the court interpreter. But I have observed other non-Spanish speaking clients who appear to have a very difficult time in immigration court. You know, there are some judges down there who will, for example, do mass deportations of unrepresented people, especially people who are detained by immigration. And if you've ever observed one of these hearings, it'll happen at a master calendar where you'll have 20 or 30 detained people in a courtroom at a time, none of whom have attorneys, not all of whom speak Spanish or English. And, you know, the judge will ask them, you know, who here, we'll ask them some basic questions. That, you know, if you don't have an attorney and this is your second appearance, stand up and basically do one mass deportation, including like 20 or 30 A numbers all at once. And who knows, out of those people who don't speak Spanish or English, who knows what they understand, right? Later on you ask them, I bet 90 to 95% of those people, if you ask them later on what just happened in the court, they would have no clue. They would not understand that they just got deported. So yeah, you know, I think that the lack of access to English and interpreters, I think, is a big problem, both in criminal and immigration law.
Okay, can you speak briefly on how has assisting limited English proficiency clients impacted your professionalism and development?
Absolutely, I think it. You know, I think it puts extra requirements on me ethically. You know, number one, another comment I sort of had a thought about this before. You know, again, I speak Spanish very well, but I oftentimes, there will be times when I have a client looking at me and I'm even speaking in their native language and I still feel like maybe they don't understand what I'm telling them. And maybe I'm being too detailed and I'm not simplifying it enough. Sometimes I will call in another Spanish speaker in my office to reiterate to them and make sure that they understand what I'm saying. If they happen to have a daughter or a son or, you know, another relative with them who speaks English as well, I will make sure to say it in English so that that can be interpreted, and then I will say it in Spanish again, just to make sure that there's clarity. And I think when you have non-English speaking clients, especially when you're talking legalese, right? You're talking about legal issues that impact somebody's life. It's so important. And we have like double duty requirement to make sure that they understand everything that's happening in their case and everything that we're doing. Another thing that I have to do, well, that I feel good about doing as well, is translating every document that I send out. For the most part is in English and Spanish. The only time I don't do that is if I know I've got like a DACA kid who speaks only English pretty much. If I know I have an English speaking client, I will send out stuff in English, but I always, for everyone else, send it out in English and Spanish translated. That's another requirement. You know, the contract, the fee agreement needs to be in both languages. It's challenging, you know, it is challenging, and there's definitely like a heightened duty, I think, on the part of us attorneys who deal with these populations, to do that, to do those things, and take those extra steps to make sure that the clients understand exactly what's going on. You know, that's fair, right? I mean, yeah, that's ethical, but it's also what's fair to the clients. I mean, I would hate to do something on a case, and the thing I think that annoys me the most and makes me upset the most is if I've got a case and I've gone through these steps and I've explained it to the client, and then I do something, and then to hear them come back later and say, well, you know, something totally wrong, like, oh, well, this is what she did for me, and I'm like, no, wait, that's not what we did, you know, and we went through this step by step. So, I mean, I think there's always that risk. I think there's always that little percentage of misunderstanding that may be going to be there with English-speaking clients as well, again, because we're talking about legal issues, which are sort of complex by definition, but, you know, as hard as we try, there's always a little bit of a percentage of misconception or misunderstanding there.
Mm-hmm. Thank you so much. Okay, we're going to go straight into Judge South, just so that you can get a judge's perspective. I'm running out of time. I'm running low.
My name is Pam South, and I'm the Chief Judge of Gwinnett State Court. I have been a judge going on 15 years, and was in private practice briefly, and was a prosecutor before that here in Gwinnett County. And I am a trial judge, so I am in court every week, and I really enjoy the job. I enjoy seeing both the attorneys and litigants as we proceed with all the cases that we have. I have been asked to talk about the issues that are raised by litigants with English proficiency issues and perhaps hearing impaired litigants. And both of those present very special problems to attorneys, I would say in the forefront, and secondarily to judges, who I think as judges, the first thing is to recognize the proficiency issues and be prepared to deal with them. And I think one of the first things that we have to be prepared to deal with in this way is the time issue. It is going to take more time, and the time must be given to fully understand what someone is saying, what issues they might be having, not only in the courtroom, but also outside the courtroom, to be sure that their attorney has had the time that they need to discuss the issues with them. In my personal experience in the courtroom, I find that we have a lot of litigants and defendants who can speak English, but not as well perhaps as they think. And that raises a new level of difficulty. How well do they understand what is happening? And do we actually have someone who may be less proficient in the primary lawyer? And there may be medical issues at play. There may be other issues that an attorney must work harder to uncover and to understand. And if it takes multiple court appearances to do that, then that's what it takes. Now, for the hearing impaired, I've had less experience, but I will note that it is also very important, if necessary, take a recess, talk to the attorney who represents the hearing impaired litigant, find out to be sure that there has been enough time spent, that there have been adequate resources spent with the litigant. And I would also say too, if that litigant is having to go outside the courtroom for probation matters, for counseling matters, for other things, that those resources are also those locations for that litigant. And sometimes the resources are not as available as you might think. And you may, as a judge, have to deal with that issue later as the issue is brought back before you.
If you could, Judge Sal, could you talk a little bit about how you have seen it and impact the level of professionalism within the department?
I do think it calls for a heightened sense of professionalism. I think all of us know that we're very busy, and we want to accommodate our clients by getting things resolved quickly. Sometimes the attorney must slow that down, maybe even against the wishes of the client, to say, whoa, let's stop. Let's be sure you understand. Let's take the time that we need. Yes, I know you want to resolve this today, but let's get a continuance and talk further. It requires not only more professionalism, but perhaps a heightened sensitivity, and maybe a willingness to spend more one-on-one time with the client to be sure that there's no mix-up in the terms that are being used, or a level of understanding about a particular issue that maybe you think the client understands, but perhaps they really don't understand. We are always trying to explain consequences to litigants, consequences of this particular action or that particular action. And I think with the language difficulty, those consequences have to be fully and completely explained.
Thank you so much for your time today. We appreciate you participating in.
Okay. Okay, so we heard from different practitioners, and we also heard from Judge Sal. I'll talk, can you hear me? Okay, I can talk loud, I got that. So, you've heard from different practitioners and Judge Sal about their experience in dealing with clients who speak limited English and have hearing impairment. But there are just certain things that we have to take note of when we're representing such clients. And you guys have pointed out as far as communication, and I want to go through some professionalism considerations and practice pointers. So recognize the culture. You don't have to know all the beliefs, the norms of that culture, or you don't have to know everything. But you need to recognize that you're dealing with someone who may not be so familiar with this culture, and they are coming from a different legal system. For example, when I represented a client who was from Korea, and I represented her in a temporary protective order. And I had to basically start from the beginning. I basically had to explain to her, it's really wrong and you can be punished for it here. And then getting a TPO, you can get some temporary relief until we're able to get a divorce. But to get her to understand the concept of a temporary protective order was half the battle. She finally got it, and then we had to just really go through the questions, and she was very private and not wanting to reveal what it was that she had to endure at the hands of her husband. So it got to the point where, under the third point, where it says educate your client, the opposing counsel, and the court. I will never forget. At closing, when I was ready to finish the case, I asked for attorney fees, and I was berated by the judge. He just turned red, he threw his papers, and he was like, I don't understand why you would ask me for this amount of money. But and I said, Your Honor, if I may, have you ever represented someone who has newly immigrated to the United States? Have you ever represented someone who doesn't really speak English and you're having to deal with an interpreter? And he, kind of looked at me, and I'm like, that adds several layers onto regular representation of a client. And that needs to be included in my fees. Now, I didn't ask for the entire amount of fees that I was due, but I did ask for more than what a typical temporary protective order would cost. So, in doing that, you have to educate the judge. So when you're actually asking for these attorney fees, you have to set the stage. You have to talk about culturally some of the things that you had to do that are different from what you did in your English-speaking cases. You have to talk about how the numerous calls come, how the consistent questions, how you have to write a letter, then you have to write the letter again, then you have to attach it to an email. When they call you and ask you the same question, you attach it to an email, you send the letter back. By the time that letter has gone through my scanner, you can barely see the print on it. But what I'm saying is communicate again, reiterate, emphasize. That's what you have to do in order to make sure that your client understands what it is you're trying to convey to them. Now, one of the things also that I've experienced is, have you guys had these type of clients when you're saying something to them and they're like this, but they have totally glazed over, and you're like, ¿Entiendes todo? And they're like, you ask them, do you understand everything? And they're like, and then you're like, okay, well, what did I just say? And they're like, all right? At that point, you've been talking to this client possibly for an hour, and you're trying to determine what went wrong. So you have to also pay attention to gestures and mannerisms. So that's very important. So when you are representing such clients, you need to always recognize their culture. You need to think about the time that it's going to take. You need to factor that into managing your case. If you're prepping for a hearing, on an English-speaking case, it may take you 2 hours. On this one, it may take you 4. You need to factor that into planning for the case. Also, you need to educate your client, opposing counsel, and the court. You also let the opposing counsel know, you know what, I know that these interrogatories are due, but it's taking them a while, right? And please factor that into consideration. Again, I can't say communicate enough. Customs. One of the things also that I've come across is is that, have you noticed that uncle and auntie are sometimes not biological? So when you're filling out paper for immigration, you need to make sure that that's actually their biological relative. And be ready to go above and beyond. What you have seen here today are attorneys. You heard Judge South say what it takes to represent these clients effectively. What type of advocacy that you're going to have to employ in representing these clients. So please take these pointers and please consider these things when you're representing limited English proficient clients and clients with hearing impairment. So always remember that ethics is that which is required and professionalism is that which is expected. And when you're representing such clients, you have to do what is expected. You use your moral compass in order to provide the advocacy and the representation that your client needs. Thank you.
I'm going to introduce Judge Christopher McFadden, who was elected to the Georgia Court of Appeals on November of 2010 for a term beginning January 1st of 2011. He is the son of the late Isabel McFadden and late Judge Donald B. McFadden, who served for 22 years as a trial court judge in Akron, Ohio. Judge McFadden graduated from Oglethorpe University in 1980 and from the University of Georgia School of Law in 1985. He opened his own law office in 1988 and remained a sole practitioner until he joined the Court of Appeals. For most of the time of that time when he was in private practice, he practiced in Decatur and focused on appellate litigation. Before joining the Court of Appeals as its 74th judge, he appeared as appellate counsel before 26 of the judges who preceded him. And so without further ado, I give you Judge McFadden, who is going to moderate our panel and introduce our panel.
Thank you very much, Jana. I appreciate that generous introduction. It embarrasses me a little bit because I planned only a sketch introduction of my colleagues, and I'm not prepared to do any more than that. Immediately to my left is Judge Melody Clayton of the Cobb State Court, who's been on that court for well over a decade, I think, over 2 decades. To her left is Judge Norman Quadro, who is a municipal court judge in the cities of Chambly and Suwanee, and chief judge in Suwanee, right? Yes, sir. As well as a private practitioner. On the phone with us is Constantina Vagenas, Esquire of the National Center for State Courts. She's the chief counsel for the Access to Justice Initiative. To Judge Quadra's left is Judge Reza O'Connor, who is the chief magistrate judge in Toombs County. And to Judge O'Connor's left is Shinji Morikuma, Esquire, who is a staff member of the Administrative Office of the Courts here in Georgia and is the program director for the Council Commission on Interpreters, as well as the Commission on Arbitration. Judge Quadro is also a member of the Commission. So I'm going to start by asking the members of the panel just to talk from their perspective what goes on in their courtrooms or in their practices with respect to interpreting, and then for the other 2 panel members, the work that they do related to interpreting from a broader statewide perspective and an even broader national perspective. So I'll start with Judge Clayton. Judge Clayton, what is it like dealing with interpreters on a day-to-day basis in the Cobb State Courts, and what's it been like?
Okay.
Is it on?
Hello? Is it working? Okay. In Cobb State Court, now, we have several interpreters on staff that handle the day-to-day matters, mostly interpreting for pleas or to help us, and they are only Spanish. That's the only interpreters that we have. They handle pleas, interpreting for defendants and their attorneys so they can understand each other, interpreting between defendants and the probation officers, that type of thing. If we have a trial, then we call in an interpreter if we have a trial, we call in interpreters for that trial, and if necessary, more than one. Sometimes you'll need an interpreter for the defendant, and sometimes you'll need, in addition, interpreters for the witnesses. You have the situation, and y'all have the materials concerning the rules, but if you have non-certified interpreters, then you also have to have audio recordings of the interpretation in addition to your court reporter taking down the English. So there are a lot of issues to look at, and if you have questions about exactly how to do it, you really need to look at the rules because they're pretty detailed on how to do all of that. But we handle it day to day pretty routinely if it's Spanish. If it's not Spanish, we hope that there is some kind of interpreter that is at least registered that we can get in there to help us. If not, we have to go back to the old time. And this is one of the reasons they put me on this panel, is because I'm so old. I've been practicing law for 35 years. When I started practicing law, and I've been doing criminal law the whole time, so I've been dealing with this type of issue from the first time it became an issue, but it didn't really become an issue in Cobb County right at the very beginning, so I've seen it grow up. And we started by using whoever we could find to interpret and doing the best that we could. And sometimes that worked out okay, sometimes it worked out pretty well, and sometimes it worked out as a disaster. And one of the worst was almost a disaster and was finally averted when a defense attorney, every time he would go to the jail and try to talk to his client who didn't speak English, and he had no interpreter, his client kept saying, "Not me, not me, not me. You're charged with rape." So the defense attorney said, "Okay, he's saying he didn't do it. We'll go to trial." So they go to trial. They're in trial. The victim gets on the stand. You know, can you identify the person that did this to you? Points right at the table where the defendant is sitting. And he's like, "Not me, not me, not me." Finally, they cobbled together enough interpretation to figure out that this was not the defendant who was charged with rape. It was not his name. They had two people in jail with similar names. Every time the defense attorney had gone out to see his client in jail, he'd seen the same guy. But they had the wrong guy. And he ended up with two injustices there. One is this guy had been sitting in jail for all those months charged with rape, unable to make a bond, and the state was unable to convict anybody of rape. Because once you've got the victim who's identified the wrong person, you're not going to get a conviction on anybody else. We've come a long, long way since then. A long way. Defense attorneys are much more aware. We have, with the Commission on Interpreters, we have rules, we have procedures, we have certified interpreters, we have registered interpreters. We have ways to help you, and you need to take advantage of those ways, because these types of injustices should never, ever happen again. It's very difficult. It's not just in the criminal realm. It happens in other realms too. But luckily, you have people that are more aware and can protect people now. So that's my historical perspective on it, and I'll be happy to answer more questions as they come along.
Judge Quadro, what's it like in the municipal courts where you sit and the courts where you practice?
Well, I've got a pretty good, unique perspective on interpreters and on Spanish-speaking defendants. I started out back in 1990 as a felony probation officer, working in the state of Florida. I worked in a rural area called Winter Garden, Florida, where there were a lot of migrant workers. And my job at that time was I went into the gang caseload, supervising gang members. At that point, since I was the only one in the office that spoke Spanish, I eventually got all the Spanish-speaking folks who were the offenders. After the comments that I heard that I don't want any of those people on my caseload because I can't deal with them. So from that time forward, I realized how important it is to have, someone that can interpret, someone that can communicate with these people. And so when I went to, I graduated from law school, I immediately went to private practice, and I'd say maybe 90% of my clients are Spanish speaking. And you run into a lot of difficulties. Now, I've been practicing for 20 years, and as Judge Clayton said, we've come a long way. And I started from, showing up to court where the judge asked me if I was the interpreter, to being able to find somebody that can actually interpret it, that's certified, that knows what they're doing. There's a lot of horror stories, like Judge Clayton said. One of my horror stories as an attorney came about is I'm in the middle of a trial on a cruelty to children charge, and we had this letter where my client had written to his family members saying the child got hurt, and I took him to the hospital. And when we're in the trial, the interpreter gets this and reads it off to the jury and says, I hurt the child and then took him to the hospital. And we're dealing with a very serious felony. And that's where the interpreter training comes in. That's why it's so important. I spoke Spanish and I caught it right off the bat. Obviously, I knew what I was asking, the question I was asking, and why that evidence was presented. But what happens if you don't speak the language and you're an attorney, or you're the judge, or you're a juror, and you're listening to this? You take what the interpreter says, as the word, the final word. So that's why interpreters are so important. And from that perspective, we, as Judge Clayton says, we've come a long way. We've gone from using children to interpret. To this day, sometimes police officers will show up on a scene dealing with, limited English proficiency folks, and they have to rely on a child to get the version of the facts, or at least a version of what the people are saying about the case. We deal with in courts before you have family members showing up to interpret on behalf of their family members, or a problem that was prevalent in Georgia, and when I first started practicing, what we called notarios, who were hired by Spanish-speaking folks because they thought notario meant lawyer. And so they'd hire these people to interpret for them, and they'd show up to actually try to work out their case and represent them. So we've come a long way, and the Commission on Interpreters has really done a great job setting down rules, especially now with the fact that people get interpreters now at no cost. When before, if you had a client, who can barely pay you as an attorney, having to hire not only you for a 3 or 4 day trial, but having to hire an interpreter for that time period and pay those fees as well, whether they're guilty or not guilty. We've come a long way, and then there's still problems that we still have to overcome, and I know there's still counties that are still charging either the defendants or the parties for the interpreter fees. But as a judge now, as a municipal court judge, I understand the problems that these judges have, that I have as a judge too now, that we have budget concerns. We have resource concerns. I also sit on the Municipal Court Judges Council, but we have judges who have to ask their counsel to be able to turn on the heater in the winter time because it costs too much to heat the room. And so to expect them to have a budget for an interpreter, those are the problems that those people are running into. And so it's slowly coming about. And you know, as you, I don't know if people have heard, there's lawsuits regarding juvenile, indigent juvenile defendants getting representation, indigent folks being able to pay their fees. We're starting to move towards getting more rights now, and I think that's a great step forward, I think, for the state of Georgia. I think we're starting to kind of get it and say, hey, we need to give everybody equal rights and equal treatment. Now, as a judge myself, again, I run into the budget concerns. We're actually thinking of a language, we're calling it language court, where it's specifically tailored to a day that we need interpreters. We're looking into maybe, I speak fluent Spanish. My clerk, I'm lucky enough that my clerk at court speaks fluent Spanish. My probation officer speaks fluent Spanish. My prosecutor's fluent in Spanish. And maybe doing court in Spanish. So we're considering a lot of things. I think the state of Georgia is moving forward. I think we're making great strides, but there's still a lot of work. And I think every single one of these of you here today at this seminar, we all need to work together to get these things done and raise awareness, because I think part of the problem that we run into is awareness. And unless that awareness is there, especially with this Supreme Court rules on interpreters that the Commission has worked really hard to get in place, we need to disseminate those and be able to get justice for a lot of people. But thank you for inviting me.
Judge O'Connor, do you have a horror story from Toombs County?
Well, I can tell you the challenges that we face in a rural area. Toombs County is located about halfway between Savannah and Macon. Our most notable town is Vidalia, with the Vidalia onion that's coming up into season. But our county sees a lot of migrant workers that come through, and the type of work that magistrate court handles, we handle civil cases where damages are $15,000 or less, landlord-tenant issues. We also, on the criminal side, handle first appearance and bond hearings, determine if there's probable cause for a warrant to be issued. And a lot of the challenges that we face is a lot of, mostly the non-English speaking litigants are Spanish. And we have one Spanish interpreter for one within 100 miles of us. And so we are sharing that one interpreter with so many different courts. And we have a federal court in Statesboro, a federal court in Dublin, which is about 45 minutes from Vidalia. So not only are we sharing it with probate, other magistrate courts, state and superior, we've also got the federal issue. So when it comes down to it, there's always a scheduling issue, because there's only so much one person can do in a day. We've had to rely heavily on the AT&T language line, which on the magistrate rules 14, I believe, that's something that could be used interpreting in civil and criminal cases, but it's not the best, and we only try to use that when we've got such a short time frame. For instance, in first appearance hearings where we have to see somebody within 72 hours. So that has been tough. There's always, not only is there's budget constraints in our court, but there's also, there's not enough staff down there with only one interpreter.
Mr. Murakamura, give us a statewide perspective.
I'm the only one up here without honorable for his name. I feel a little intimidated. I was appointed to staff the Commission on Interpreters about a year ago. I've been working with the Commission on Dispute Resolution since about 2006 as its director. So I've come at this, at least from a judicial and professional level, relatively recently. I also have the perspective of being an immigrant. I remember being in the Bronx and and walking around with my mom while my dad was at Columbia, and walking around with my mom who didn't speak English. And since I picked it up more quickly, I was interpreting for both of us when we went out from, ventured out from home in the Bronx. I was still trying to figure out the language then at the time. I remember that I remember I was in a very deep conversation with a butcher, asking him why, well, you know, you call fish fish and chicken chicken. Why do you call cows beef? And for the poor butcher to look at a 3-year-old and try to ask him this question. Anyways, I'm sorry. But I come at this from a relatively new perspective from about a year ago, and it's taken me and Justice Blackwell, we were both assigned to the commission at about the same time. It's taken us about a year to kind of get our footing, try to get some critical mass of information about what's going on with interpreting and what are the needs. I can tell you that one of the commission has rules and standards. It's been very successful in disseminating those. We have standards and credentialing for interpreters that we get help from the National Center for State Courts, but there's still a lot of work to do, and I think some of the most basic work we need to do is data. We don't have good data, unfortunately. Some courts, some of the metro courts where there are large immigrant populations, some of the metro courts have interpreters on staff, and some actually have kept records that we can look at for how many times interpreters were needed in what languages. We just got a spreadsheet from Gwinnett County. It's spending for 2014. It's about $500,000 that they spend on interpreter services, not including their staff interpreters. And we can cobble that information together, but unfortunately, courts statewide are not necessarily used to collecting this data, or frankly asking about whether anyone needs interpreted services. It's a relatively new thing compared to the history of the state, and people are adjusted. And so we are trying to get data from courts and see if we can't use that to supplement the work that we've already done on a statewide language access plan to essentially create a roadmap for the next stage for language access in Georgia. We have a lot of work to do. You look at those of you who were here this morning, you heard Justice Thompson, Chief Justice Thompson, talk about how important interpreting was in his State of the Judiciary address in February. He mentioned again, as he did in his 2013 or 2014 address, that we don't have enough interpreters in enough languages. And when the Chief Justice speaks, we hear that loud and clear. We know that we have a lot of work to do in terms of recruitment. I think we're doing okay now, but we must do better. But we also need to know what languages are needed and where and in what volume. And then try to encourage people to enter the field when sometimes work is kind of spotty. You have to travel from court to court. It's not an easy problem to solve. It's not just a matter of putting a bunch of people into a class and then letting them become certified court interpreters. But we're working on it. Judge Quadra is on a commission, Judge Fadden's on a commission, and we're working hard on it. But it's a lot of work, and we are taking our cues from the National Center and from other states, and gathering as much information we can as, so that we try to do this right and do it quickly as possible.
Ms. Vagenis, can you give us sort of a national perspective on it?
Good afternoon, everyone.
Good afternoon.
Janet, you'll tell me if for some reason I've spoken up and it's not my turn, but it looks like you've indicated that it's that I'm on. My name is Constantine Vagenis, and I'm sorry I can't be there in lovely Georgia with you all. I'd love to. I'm in rainy Arlington, Virginia today, and I also apologize, I cannot hear you, but it appears that you can hear me. So I will start with my presentation. I did have the phone on for a while as well because I thought maybe I could hear through there, but apparently you were catching some noise from a phone call that somebody was making on your end. So I will get started. Again, I'm Constantine Vagenis, Chief Counsel and Director of Access to Justice Initiatives at the National Center for State Courts. For those of you who are not familiar with the National Center for State Courts, I'll tell you a little bit about it. It is an independent, nonprofit court improvement organization and it was founded at the urging of Chief Justice Warren Burger in 1971. It did start as a clearinghouse for research, information, and data to support improvement in the judicial administration of the state courts, and it has grown exponentially into a full-service solution provider for the state courts. Turning to the work specifically of our language access services section, I'll now give you a brief overview of some of the activity that's been ongoing at the national level and the resources that we've made available to states. You should all have with you our recent call to action. We sent over hard copies, and I do hope each of you has them, and that's what I will talk about briefly first. Second, I will then give you some information on our Video Remote Interpreting Network project. I wish we had that up right now because we could use it to remote me into your meeting. And lastly, I'll give you an update on our testing program. So with regard to the call to action that you've got before you, hopefully, in October of 2012, the National Center for State Courts held a Language Access Summit. There were delegates or representatives from nearly every state in the country, and that's over 300 delegates. The summit was held to obtain a comprehensive assessment of language access in the state courts across the nation. And I'll give you just a few of the most important components of that summit. There was a team exercise component in which participants from each state met as a team to develop priorities and action plans. The top 3 priority areas that were identified were, number 1, training judges, clerks, and interpreters in language access. Number 2, identifying the need for language access services. And number 3, utilizing remote interpreting technology. After identifying the priorities, the teams then identified their specific action steps, which actually form the crux of the call to action. That's Chapter 3. The 9 action steps serve as a roadmap for states to use as a guide to implement or improve their language access programs. And again, that's in Chapter 3 of your call to action. And we've had an overwhelmingly positive response to the entire call to action, and specifically Chapter 3, and states have said that it's just been so helpful in running their language access programs. Coming out of the exercise, as I mentioned, VRI was definitely a priority. For example, I'll give you a couple of examples of individual state actions in that regard. A majority of the participating states and territories reported that they are making it a priority to explore remote interpretation by way of telephonic or video conferencing in order to provide quality, timely court interpretation. Several states provided that they had successfully implemented VRI, which is short for video remote interpreting, and wanted, or virtual remote interpreting, some people call it. They also indicated they wanted to expand. Several states were interested in utilizing VRI, and a number of states, up to 15, were exploring and evaluating VRI. So clearly, emanating from this call to action, we learned that video remote interpreting there's a very strong need and desire to have this in the state courts. Since then, we have dedicated a lot of time and resources to this because we have seen that you all are demanding it. One of the projects on which we have been working is a video remote interpreting or virtual remote interpreting network project. What we want to do is basically create a cloud to create a shared network of virtual remote interpreters. We have built the database, the infrastructure to this cloud. That's phase 1. And it's been somewhat of a Herculean task because we have been entering interpreters. There's an incredible verification and QC process that goes into it, and you can imagine how important that is. So we have spent a lot of time doing that. The next phase will involve our building the vendor interface, and bringing the vendor in will help to create, to connect everyone in this cloud. Also, simultaneously, we've been conducting technical assistance across the country, specifically video remote interpreting assessments. As we gear up to roll out the pilot, this is helpful to us because it helps us see the varying degrees of readiness for VRI across the country, and it also helps states assess their own needs and assess what it'll take them to get up to speed.
And when I say get up to speed, there are some states who are already somewhat there with regard to video. There are other states that we are just helping get to the point where they have audio to help them get in touch with the network, because it will also provide, if you don't have the capability to do video, we will also be able to do just audio. So it's not like we have this standard and everybody's got to meet it overnight. We're working with each individual court across the country, including in rural areas, in helping them get to where they need to be. Or I shouldn't say get to where they need to be, to assess where they are, and then we kind of develop where they want to be. And then if folks want to join our pilot, then we're working on that too. So it's a learning process, the whole thing. Lastly, I know I don't have too much more time. I'll tell you a little bit about our testing program. The National Center for State Courts supports court interpreter certification across the nation, including for states and territories. The individual states and territories establish their own certification programs. We are the repository for the written and oral exams used by the states. We develop and maintain exams, oversee the recruitment and training of the oral exam raters that are used for scoring the oral exams. We also establish and require compliance with specific standards for the administration of the written and oral exams. And this ensures that the examination process is standardized across the states and territories. We have an inventory of 29 different oral court interpreter exams in 20 languages. And currently we've got a number of initiatives. I'll give you the highlights, testing initiatives. We are releasing 5 revised versions of oral court interpreter exams in 4 languages: Spanish, Korean, Russian, Vietnamese. We're releasing 2 updated written exam versions, updated scoring dictionaries in 5 versions of Spanish. We are recruiting and training 21 oral exam raters in 5 languages: Arabic, Khmer, Korean, Portuguese, and Punjabi. And we're developing a comprehensive test administration manual for state program managers. We're also revising exam scripts and audio recordings for 4 interpreter exams: Arabic, Egyptian, colloquial, Levantine, Vietnamese, and Spanish. And lastly, we are conducting online training and telephonic meetings for over 100 raters across the country. And we are giving ongoing support with the use of secure electronic transmission processes for all exam materials. That's about it, folks. For now, I know I'm getting an indication that my time has ended. Please call me if you need anything, if you need technical assistance. We do not help only in the video remote interpreting area. We help in other areas as well. We can help you draft your language access plans. We can help you if you want to just proof or QC the plans or expand. And okay, I'm being told my time is up. Thank you so much. Bye-bye.
Thank you. Well, this is a stakeholders panel, and those of us up here are hardly the only stakeholders. So let me open it up now for some questions and comments from the floor.
Every time, I know budgeting's an issue. That's okay. What kind of ideas or thoughts or
Stand up if you would, and
so they can use
here's a microphone.
In terms of the budgeting, what kinds of initiatives is the commission toying with and working on and addressing the budget issue? Because I understand that's like the #1 complaint, or not complaint, but concern that the court has whenever we request interpreters. Especially, and my biggest concern is whenever there's guardian ad litem's involved in a case and there's a bilingual, or there's someone who's monolingual who cannot communicate with the children or the parents who do not speak English. And so there's a breakdown in communication between the guardian and the family.
I got handed the microphone by my commission member, so I guess I'll take the first shot at it. We know the question, if you didn't hear, was what can the commission do about the funding issue at the local level in order so that courts can afford interpreting services, to provide interpreting services. I can tell you that the commission itself, doesn't have the money to support interpreting services statewide. I wish we did. It would make our job so much easier.
I guess my question should have been rephrased. Is there a liaison with the legislature to work out perhaps the budgeting, or is there some kind of compliance? Is there a compliance officer? In terms of budgeting, or to see how the funds are being spread across for the issue. It's just concerning to me that sometimes there's a breakdown in the investigation. For guardian ad items, I just feel bad for some of the guardians who enter into the cases and they cannot communicate with the family.
The cases involving children particularly are tragic, and there are options to obviously approach the legislature to see if they're willing to provide funds to the county and municipal level to support those services, perhaps particularly for juvenile cases or cases in which there's a guardian ad litem that could start at that. In terms of compliance, Judge Quadra and I talk about this quite often, but there are Supreme Court rules about the use of interpreters, but as Jana pointed out earlier today, Georgia has a non-unified court system, which means the Supreme Court, the highest court in the state, can't tell the lower courts what to do. And so it's really a matter of offering ideas and then hoping that people will adopt them because it makes practical sense.
Except you can always appeal. You can always make your record and appeal. The rules say that an interpreter shall be provided at no cost to any non-English speaking person whenever the non-English speaking person is a party or has been subpoenaed or summoned or has otherwise been compelled to appear in a proceeding. That's under criminal cases. And then under civil cases, it says each non-English speaking party shall have the right to an interpreter at each critical stage. And I'm just cherry picking out of here. Read the rule. Then that's rule. That's in. It's attached to these, and what I was reading from was Roman numeral 3 and Roman numeral 4. Roman numeral 7 says the expenses of providing an interpreter in any legal proceeding will be borne by the local court or appropriate governing authority. Now, sometimes you have to be brave. If you got a judge that isn't going to provide the interpreter, cite the rules, make your record. These rules are rules of the Supreme Court Commission on Interpreters. Okay? Now, maybe when you get up to the Supreme Court, they won't enforce their rules. I don't know. Is that a lot of trouble to go to? Yes, it is. However, sometimes you have to go through trouble, and if you get a Supreme Court opinion that says, no, we're not going to do this, then you go to the legislature. In the meantime, go to the legislature. But right now, the funding is on the local court or appropriate governing authority, and that's the problem. Your question seemed to go to, what about funding as if it's statewide? There is no funding statewide as far as I know, and there's not any provision for it. But I would encourage, don't be timid. Lawyers don't need to be timid. I know all of you are not lawyers, but if you're a lawyer, what'd you get into this for if you're not brave enough to stand up in front of a judge and say, Judge, this is the law. These are the rules. I'm asking you to follow them. I'm respectfully making my record. And then take them up. Okay? That's my advice. And I'm, preaching.
I guess I'll preach too for the interpreters. You can have a great lobbying group. There's a person right there that's sitting there she's kind of hiding a little bit. Her name is Linda Smith. And she helps out tremendously. And I know there have been other people with similar issues. And I think, I know, that she'll, go up to bat for you. So, but you guys, as interpreters too, and attorneys and whoever else is in this room, if you're interested in this, and this is important to you, we got to keep pushing. And, us as commission members, we can only do so much. And we're at the forefront. We're trying to, steam ahead and do what we can. But we need some backup. We need to have our backs as well. So if you want this done, and I as an attorney, I happen to do what Judge Clayton says to do. And you stand up and you make a record, and you do your best and you push forward. And there's other avenues that you can use by appeal. Sometimes you can use the board to help you out. But you have to be brave enough to step ahead and advocate. Whether as an interpreter or an attorney or whatever profession you're in, that's what you've got to do. And as far as budgeting is concerned, it all comes down to money. But we do know that the Department of Justice will pull federal funding if the state of Georgia is not in compliance with language access.
Yeah, one needs to be aware of, if one pushes this stuff in litigation, you need to be aware of the Dear Colleague letter from the Department of Justice, which is putting pressure on all the states. Because we, as has been said, we are a non-unified judiciary. These budgeting decisions are made on the county and the municipal level. So we're not going to accomplish this in one sweeping statewide swoop. It's a battle. It's an incremental battle.
And since on the local level, since funding comes from that, when I first came to office, they were using, for example, for my first appearance hearings, they would at my first Spanish speaking defendant, they brought in another Spanish speaking inmate to interpret, and so that's something that had been going on for the past 10 years. And if it was if there was a Spanish-speaking litigant who wanted to file paperwork, they just got somebody from the office next door to try to help this person. So it was something that wasn't even on the radar of our county commission. It's something that we had to petition to go to the county, to a county commission meeting and say, hey, this is important, this isn't fair. And most of all, we could all get in trouble. And so sometimes you need that. Sometimes you've got to have that for them to be able to make some moves.
Question back there.
Well, thank you. My name is Marcela Langua. I'm a certified court interpreter. And I am just thankful to the bar and to the parties that put this together, first of all. When you say budgets, of course, we're the interpreters, so when you say they don't have money to pay us, it resonates because many times they'll say, okay, get the interpreter, and as soon as we get in there, they'll say, well, get her first so we can get her out of here, because we don't want to have to pay the interpreter. I've had to come in and I've been called to counties where they will line up 6 defendants, and the public defender has said to me, oh, please translate these. Tell them all that for the arraignment, they actually have to bring somebody that speaks Spanish because we don't want to have to pay the interpreter because she charges too much. It's still happening in many counties. They're not horror stories. They would prefer to use a clerk or someone, and I have gone to, the interpreters cannot be timid either. I have gone to superior court judges and said, but Your Honor, and I've quoted the rule, and I've been called smartass, and that's some of the nicer names I've been called in rural areas. I have to travel from Rome to DeKalb. I'll travel from Rome to Macon. I wanted to just come briefly and say that we appreciate what you're doing because we are officers of the court as well. And we represent ourselves with a lot of professionalism. The AAIT, we have NAJIT fortunately coming to Atlanta in May. The National Association of Judiciary Interpreters will be here. It would be wonderful to have people from the bar come to the NAJIT conference. We've made a lot of progress. We're better than many states, but we have a long way to go before we look at interpreters as officers of the court who need to participate. When we interpret the law, we interpret what the judges say, what the defendants need to understand, so they are meaningfully present in the process. And unfortunately, there are still courts that lock the doors and will walk out and say, is there anyone who speaks Spanish? Whether it's the janitor, it happened to me. I was sitting outside the courtroom and the judge actually sent the bailiff and asked if there was anyone who spoke Spanish. And then when I submitted my bill, I got a letter saying that I had submitted a fraudulent invoice and that I was blackmailing the court for asking for $100, even though I was there for almost the whole 2 hours. And that's what I want to bring up, that it is not happening in Fulton County. Maybe it's not happening in DeKalb or in Gwinnett, where you have a large population and a great budget, but it is prevalent throughout the state. And I know because I travel around the state. But in quoting the rule, I have gone to Superior Court judges who tell me, well, it says they shall. It doesn't say that they must provide an interpreter for criminal cases. And when you quote the rule, just last week, I had an attorney that used the sister. Even though I showed up, they said, well, it's not a contested case in a civil case. So, there's always a way out, and we need to find a way to make it enforceable. Thank you.
Could I just follow up on that for just a second? Unfortunately, there are an awful lot of people who don't understand the difference between being able to say, "Donde está el baño?" when I go to Mexico, and understanding what is going on in court when I go to Mexico. And I think that in addition to educating people as to the legal aspects, in some of these more rural areas, you also need a PR campaign about how difficult it is for people. I mean, think about Mr. Murakuma's example of not understanding the difference between beef and cow, okay? Legally, that makes no difference. But think about if it were a legal matter. And I think if you try to think of examples, for instance, people's children going on a vacation in a foreign country and getting arrested for something they didn't do, and not being able to understand the system there. What if what if the country they come from doesn't have juries? Just interpreting, do you understand you have the right to a jury trial, means absolutely nothing. Okay? So, and an interpreter can interpret that in a way that means something to the person. Using Google Interpret does not tell the person anything. But y'all are all, y'all are the choir. What I'm telling you is, part of this is PR. Think of things and ways to talk to people to win them over to your side so that you can then get the dollars.
I'm going to comment on that too very briefly. Hold on to the microphone, I won't talk too long. One of my view of the matter, or part of my view of the matter as Vice Chair of the Commission, is that part of the Commission's long-term responsibility is the professionalization project. It's not unique to interpreters. It has gone on throughout the history of work is learned professions try to develop. They develop in terms of the standards that are expected of persons practicing the profession, and they develop in terms of what the profession is entitled to expect, particularly in terms of compensation. Interpreting is hard. It is. I don't have to tell you this. You know it. Many of you know it far better than I. You're absorbing a tremendous amount of input, producing a tremendous amount of output very fast under a lot of pressure, and I understand it gets very fatiguing very fast. Our standards for certified interpreter are very high. Ms. Smith regularly reports to the Commission about the test results and how many people fail. These presumably are people that are bilingual. So, and as an appellate judge, I'm very much concerned about the fact that mistranslations occur. And as indicated, the potential for injustice is terrible about that. So I just want to convey to you that I understand, as a member of the Commission, that part of our long-term responsibility is to make certified interpreting the respected profession, the viable career opportunity for a talented person that it ought to be. Go ahead.
Hi, my name is Christina Giralde. I'm the new unaccompanied minor attorney at the Latin American Association. So if any of you ever need assistance with those issues, please feel free to reach out to us. I'm actually late today because of an interpreter issue that I wanted to mention. My clients and I were ready to go this morning at Fulton County Juvenile Court, 8:30 a.m. We had to wait until 11:30 just for the interpreter to show up. All of the parties were present except for the interpreter because there was only one interpreter, as many of you know, at that court, and he is shared among all of the different courtrooms. And so we had to wait our turn. And, I represent minors, and I just think, not only is it an inconvenience for everybody, which we all know, but then the minor is scared of the whole process and is waiting, and she's biting her nails, and I could just feel this energy of nervousness about what is going on. Why is it taking so long? Why can't I see the judge yet? Coming from her and trying to calm her down. So I think it's the very small level things like this that kind of make a big impact on the people that come before the courts. Not only is it a professional for everybody to just sit there and twiddle our thumbs while we're waiting just to be heard, because there's not an interpreter around when there's plenty of certified interpreters that should be able to be accessed in these situations. So I just wanted to raise that issue and bring up an example, and apologize to the panel for being late. Thank you all for also putting this together. It's a wonderful thing to come and actually have a space to talk about these issues.
Anything else? Anybody else? Behind you.
Just a quick question to the panelists, to our judges. Can you give us some quick tips on how you guys prefer to handle having interpreters in the courtroom, and how you like it to proceed? I have some judges who prefer, headphones, and some people who prefer it to be open and you have a certified court interpreter. Do you guys have any preferences on how to do interpretations, and any guidance you can give us attorneys on when that occurs in court?
Well, I'll leave that to the judges with the power to take evidence.
I don't know that I have a preference. Perhaps if I had a long trial going on where I had a foreign speaking person sitting at the table that needed every word interpreted, it would be helpful to have some headphones going on with that. But generally, for my general run-of-the-mill type of thing, I use, I'm talking, the interpreter's talking, the party talks back to the interpreter is translating simultaneously, and we have no problems. I don't have any problem with that at all.
At least my experience, both as an attorney and as a judge, the best interpreter is the one that you don't notice. The one that makes it seamless, that you, after going through the trial or after the hearing, you don't realize that you had an interpreter and that everything went seamless. The simultaneous translation helps a lot. Simultaneous interpreting, excuse me, is great. The headphones work really well if you're in a jury trial, because then you're not, at least as an attorney and I'm sure as a judge too, it gets distracting to hear that simultaneous conversation. So as we all do, we tend not to just focus on one thing. We tend to go to other stimuli. So I think the headphones are really great when it's a long hearing. But you know, I think that the best type of interpreting is when you just don't realize that there's an interpreter there.
And for purposes of magistrate court, our court hearings are generally short, so we've always just done open hearing, and that's worked out great.
All right. Anybody else have? John.
I was just gonna. Can people hear me in the back? Okay. I just wanted to make 2 points that I think that is very helpful. One that I think is important to talk about the issue of interpreter fatigue, and I think Marcelo is going to talk about that up next later, who's one of our certified interpreters. But depending on the duration of your proceeding, part of the advocacy that Judge Clayton was talking about, you may have to push for them to appoint not one, but two or more interpreters, just depending on how many parties there are, that need language services, and how long the proceeding is. A lot of times, people don't really understand how mentally exhausting interpreting is, and if anyone is up for the challenge, I would invite you on our next presentation to just partner up with the person next to you and whisper to them and interpret what you're hearing in English to the person, and see how long it is before you get tired. And that's in the same language. Your brain is not having to do that in between two languages, and I think you might be surprised at how quickly you go, okay, I'm done with this. I'm not going to do that anymore. So thinking about that you may need to push for two. I know in domestic violence cases, a lot of times the technology in terms of using headphones, interpreters, they pay for that. They pay for that equipment oftentimes. And so you may not have an interpreter who is able to have the headset where she can give one headset to one party and one headset to another party, and he or she can be back there so that she doesn't have to be, or he doesn't have to be right between them. And when you have to think about that in a domestic violence case, that victim is not wanting to be that close to his or her abuser for the purposes of interpretation. And so you, in that instance especially, you really need for each litigant to have their own interpreter. So just think about those issues of interpreter fatigue, how long your hearing is going to be. Is it going to be just an hour? Is it going to be multiple hours, multiple days?
Can I say something? Thank you. As an interpreter, I always find a lot of issues when it comes to the trials, to the point where I virtually myself do not accept any trials anymore for several reasons. Number one, when I get called for a jury trial, the court expects me to block a certain number of days and to guarantee them that I'm going to work 2, 3, 4 days, 5 days, but 98% of the time as an interpreter, I show up and they say, well, the case settled. And so I get paid my 2-hour minimum, but then all those 4 days that I blocked for this trial are lost to me. That's the number one thing. The number two thing is that I've always tried to convince the court to have 2 interpreters working simultaneously and taking turns. And they say, no, that's too expensive. And my health is also expensive, so I said I'm not going to do a 3-day trial on my own. And the third thing is that even when I do have, let's say, 1 day that I could work on the trial, and they call me, a lot of times they want the same interpreter for the whole duration of the trial. And let's say if I only have 1 day available, they would say to me, no, if you're not available for the whole trial, if you're only available for part of the trial, we're not interested. It's like a lot of judges prefer to have the same interpreter. I have never understood why, because we all do the same work and job, but that's one of the issues, or the 3 issues that I've always encountered, and why I have decided myself not to accept any trials in court, personally.
Jackie Downs, certified interpreter. I'll try to be very brief. I want to praise the judges in Forsyth County because I have been interpreting for Forsyth County for 19 years. And they started from the start to be very proactive with me. Sorry, I'm not a public speaker, so I'm a little nervous. And they would bring me to their chambers and discuss issues that were possibly arising or suggestions. And that's very helpful. So if judges can do a little bit of that, that would really help out with the whole process. Thank you.
Hello, I have a quick question. I know that when I was going to court, I would, and I don't know if you do this, Judge Quadra, you end up hearing both the English and the Spanish, and so you recognize when something was not interpreted correctly. And so from the judges, I would like to know if you do have an attorney who recognizes that, how do you want that objection made? In one particular case, I got so flustered, I was like, wait, and I forgot to say objection that was not, correct. But do you just want an objection? Do you need some other form when there is something that has not been correctly interpreted?
I've run into that problem as an attorney and as a judge. Again, lucky for me, I speak Spanish. And what I've always done as an attorney, I've stood up and objected. I've made an objection, and sometimes I've been lucky enough to have two interpreters in the room. So, like, I don't know, everybody baseball fans here, and you have a strike and you don't believe the umpire, so you go to first base and you get the second call. I've done that. I've said, Judge, I'd object. I believe it was improperly interpreted. Maybe we ask the second interpreter to give an opinion, and that's worked sometimes, but we don't always have that luxury. And it's not a science. It's an art. Now, as a judge, that's a difficult call, and I've heard it, and I've asked, is that correct, or had the person repeat the testimony, the witness repeat their testimony to make sure that the interpreter heard it correctly. Because again, it's not a science; it's an art, and we're human. We make mistakes, but I've stopped and made sure that the information was given correctly, or if I didn't hear it correctly, I just asked for clarification. That's been at least my practice.
I think as an appellate judge, this is actually something I can talk to a little bit. And it's something that concerns me very much because we really haven't got much law dealing with this problem. It's, as I mentioned, a very serious problem. What you need to, number one, you need to get the trial, as with anything appellate, don't appeal, get it fixed at the trial court level. And Judge Quadra's approach of just repeating it over is I think, usually the simplest solution. But if that doesn't work, you need to get a record that we can look at the appellate court, and that maybe the court reporter's audio recording of what has occurred. But you need to make a record so that when I see the documentation, I can make the determination. And you need to make a record that isn't just he said, she said.
I was going to mention on that point, I think it's important, if you have a certified interpreter, not that it can't, it's less likely to happen, but everyone is human and may make an error. But especially, as I mentioned earlier this morning, when there is the use of a licensed interpreter who is either conditionally approved or registered, or the person serving as the interpreter is not licensed at all, the Supreme Court rule does require that there be an audio-visual or visual recording of the non-English testimony. And so what that means for the purposes of an appeal is that the court will be able to have a transcript of the non-English testimonial statement so that it can be compared with the official interpretation to make sure that there was an accurate interpretation there. However, when you are using a certified interpreter, that is not required, and so your transcript is only going to be of the English testimonial statements. And so in those situations, you will only have the interpreter's interpretation on the record.
And
I can tell you that as a trial judge, one of the scary things is that we're supposed to instruct the jury that if you speak the language, you have to ignore your understanding of the language and go with what the interpreter says. And I've had to look at jurors and say, can you do that? And they say yes. And I always wonder if they heard something different, if they'd be back in the jury room saying, no, that's not what they said. Without the legal training to know what might be different. So that's a scary part because I don't speak fluent Spanish. I speak, donde está el baño? Tiene abogado.
I have another question that was just brought up to me and I don't have the answer. So this question, I guess, is also for interpreters, but for the panel. It was brought to my attention that some interpreters have been called to be witnesses for the cases they have interpreted for, even though we know that that is not acceptable, but apparently it's been done several times, and I was wondering if an interpreter here or some of the interpreters here have been called ever to testify against or about a case.
Are you talking about during the trial itself or at the new trial, at the motion for new trial?
During the new trial.
It's been, in situations where, for example, an interpreter interprets for a victim, and days go by, and there could be a trial going on, but days go by, and then the interpreter is called to interpret for a defendant. Now, you may not know that the two are associated in the same trial, but then the interpreter is called to the witness stand because previously they interpreted for the victim.
So the idea is that it's a conflict.
Exactly.
Is it
Well, it shouldn't be, in my view, it shouldn't be, but it seems that the impression I get is that the attorneys may be using this as a ploy in a way to win the case, or I don't know. I'm not quite sure exactly what's going on.
Jen?
There are two red flags with that. One, when an interpreter is present, for example, and they're speaking, there's a confidentiality issue. And so whatever is said is confidential. Of course, within they shouldn't be going back and speaking further. And then also just a point, privilege between a client and an attorney is not disturbed by the presence of an interpreter here in Georgia. And so that privilege is also still there, just outside of the court setting, of course. But when that happens, and I think this was brought up, the commission had a great workshop that was spearheaded by Judge Quadra in November, and that this same issue, I believe, it came up, and one of the interpreters stated that when that happened, they said, I can't do that, because it happened in that situation. The interpreter was certified as a legal interpreter and worked in the courts, and was also certified as a medical interpreter, and so happened to know that same party from the hospital, and the case was about being at the hospital. And so they tried to get that interpreter to testify regarding what had been going on. But they said, ethically, I cannot do that. And they stood their ground. And I see we're out of time. So let's give them our...
Thank you.
We have now a 10-minute break. If you need to use the restroom, check email, or whatever you may need to do, you have plenty of time to do that. And we will come back with our keynote speaker and finish up the rest of our day. Oh, that's fine. This is the portion.
Good question, Michelle. Yeah, I know. We couldn't have the questions. Yeah, good.
You never, it's all just cultural.
And he's English. I mean, he could speak.
I didn't know what I had done. You got me real good. You said congratulations. Oh, thank you. Nice to see you. Nice to see
It's my phone.
Been getting good pictures.
Weren't you in the one
I don't know. I was in one
Hi, I'm
Hey,
Brianna.
hey.
We just talked on the phone. You were a guardian of mine. You come to speak with me, and then your office called, and I heard you representing
Oh,
her.
yes,
and I was like,
yes,
it was like
yes.
around Christmas time.
Yes.
I was like, no, she's coming to meet with me. She is not regaining me. So that was like the crazy issue or something like that. Because I get all resolved.
Yes.
Right.
Right before, like always, you know. We used to get the big.
I had a mic, but I turned it off without Christmas. Maybe it thought.
That's good. You take
Yeah, we'll burn it down. Like, hey, you should go to she's a push.
it's a good one.
Yeah.
Yeah, I recognize all the faces.
We'll say something
Nice,
like
nice, yeah.
names with a name. So talk to the phone, not my phone.
You doing? Okay.
Thank you.
I was trying to turn it.
The only thing you know about the deli is the
Oh, that's okay. I got
Hey, listen. That's the neighbor.
Sí, de la última de noviembre.
You okay?
I'm good.
Maybe 25% chance of Good to see you.
Good to see you.
Yeah, that's what.
Kind of a lonely profession.
Right, I know, and you know, I'm one of the, I'm just adamant that if somebody needs, see, they know, supply the interpreter, pay for it. I had a trial this morning, called it in the trial, needed an interpreter. Nobody has got an interpreter. There's one person in the court, there's one person in the courthouse that sees and is supposed to be in charge of those interpreters for trials. You know, our contract attorneys are not there for trials, they're for the, you know, quick stuff.
Yes,
so
correct.
to facilitate court.
Exactly.
And, no, you know, not there. It's like, you know, then it turned out that the case was really bad. The prosecutor said,
Yeah.
so,
No, just one coming to the rest of
oh, really?
Spanish, and I don't speak any Spanish, but the interpretation was a and you're so then she dismissed the jury and everybody on the afternoon, and they came back and admonished his attorney and told him the next morning you come to another interpreter that you think is more qualified.
That's one of the reasons why I love working there.
And so I worked there. What happened? Like the attorney was there trying to find and the attorney was so sorry. About this case isn't that crazy? It was good to see you, Judge. Good to see you. Pero no lo voy a llamar a juicio. Oh, okay, so that was only before two or what?
No. They could put you pagan todo.
First thing is,
Whether they
those rules.
If it's a 4 day, well, it's a blocking for 4 days, they're going to pay you for 4 days.
Well, they never asked you to run for 4 days, but they asked you to run.
I mean, it's on a day at a time.
Yeah, it's the same course.
Picture they saw she shouldn't.
Rarely.
And you may not answer this. Is there a legal requirement? Interpreted because they understand like does he have a legal requirement?
Who is the AOC?
I don't know that. I think it's best to if it were me, I would.
You don't have
I just would appreciate it would say,
if that goes through, and I'm much less satisfied, I guess.
don't say when or what.
Oh, so they're no longer in that tells you how long you haven't called me.
Well, you know.
How's your
Bernadette. I'm being summoned.
That's irrelevant. This person is a professional. The fact that the interpretation is and change your words. Yes, and it's like why that's his interpreter, whatever.
Well, you know.
Supervised visitation, then whoever was there is a much better person to testify about that than the She heard everything.
You know, and when they go to trial and like we have to transcribe all of the different circumstances, that it is more expensive. I mean, sometimes it is way more expensive. They had an interpreter from the beginning.
Just like you have your checkups before you travel down the road.
Exactly.
Also, I mean, you get subpoenaed to testify. To them blank forms that they fill out to file as a motion to quash the so that you quote the rules, the Supreme Court rules, and this and rebut with the clause so that it's not just you, but you have a
All right, we're going to go ahead and get started with our next speaker. And I've been ordered to not go on and make it brief, and so I'm smart enough to know I should follow the judge's orders. So I would now like to bring to you our keynote speaker, Justice Keith Blackwell, who is the most recent member to join the court appointed by Governor Deal. And Justice Blackwell currently serves as the chair for the Supreme Court Commission on Interpreters. And it's been such a pleasure to work with him. He came on and he was genuinely interested in learning about these issues and getting up to speed. He succeeded Justice Melton, who had chaired the commission very successfully for a number of years, and Justice Blackwell has really been genuine. It's really great, and so we really appreciate him for being so gracious and supporting this program and getting the Supreme Court's support behind this program. And so now he will speak to us about, or begin our discussion about ethical considerations in the context of language access. Justice Blackwell.
Good afternoon. Good afternoon. Okay, can everybody hear me? I've got another little mic here, but I think I'm just going to stick with this one. It's a real pleasure to be here today. I can't tell you how much it means to me that it seems like we really do, throughout the judiciary and the legal profession, have a new emphasis on ensuring equal access to justice for all, including folks who are limited English proficient. You know, it is a real challenge for our judiciary and for the legal profession as a whole. We have an increasingly mobile society, which means we have more and more international visitors here in our state and in our country. It is an increasingly pluralistic and diverse society. And increasingly, I think, unlike in past generations, we have generations of immigrants who now come to this country and don't quite as readily or quickly assimilate and necessarily learn the language. And so They have increasing difficulty in dealing with the court system in particular. Going into court is an intimidating experience for most English speakers who were born and raised in this country. For most of them, even if they grew up watching Perry Mason or more recently Matlock, it's still an unfamiliar and intimidating experience to go into a court. You know, I'm a lawyer, but I've said before, even I would not wish to be cross-examined by a lawyer for any length of time. And I've had the benefit of going to law school. I understand the system. I know what the system's all about. Going to court, for most folks, is not a pleasant experience. Even if you understand the language and have some sense of what's going on, I can only imagine how terrifying it would be for someone who didn't speak the language that everybody else in the courtroom is speaking, and who doesn't have kind of a cultural understanding from the days of their youth as about what's going on in the courtroom. Now, the number of LEP persons who come into the judicial system, it poses a real challenge for the courts. We have a commitment in this country to the notion that everybody who walks into a courtroom is entitled to due process. We have a commitment in this country to the equal protection of the law and therefore equal access to the halls of justice for all persons within the jurisdiction of this country. But the courts have limited resources, and a lot of our courts don't have a long history of knowing how to deal with these issues. Like I said, the emphasis on equal access for LEP persons has been a fairly recent phenomenon. And so we don't have a long history of knowing how to deal with these problems. Those challenges are especially acute with pro se LEP persons who come into court without representation. Well, what I wanted to talk about in my remarks are the challenges for lawyers. Not so much about the challenges of courts dealing with unrepresented LEP persons, but the challenges for lawyers who are representing clients who are not proficient in English. There are some very serious challenges for those lawyers, and some of those challenges have ethical implications that I think we need to think through. Now, like any talk on ethics, my remarks are going to raise a lot of questions, and they're going to provide very few clear answers. In part because that's the nature of a lot of issues in the realm of ethics and professionalism. There are things we need to think about. There are things we need to work through. Quite often the answer to most any question is, well, it depends. You know, as lawyers, we were taught in law school, if a client asks you a question about, can I do this? The answer is almost always, well, it depends. And what follows the answer, it depends, is where you really give advice to the client. The same is true in the realm of ethics. There are certain things that are clearly off limits. There are certain things you clearly always can do. But most often in the world of ethics, certainly in the world of professionalism, the answers almost always are, it depends. And so it's more important that we just flag the issues, that we raise the questions, and that we think about these things as we go through our practice. You know, there also aren't clear answers in part because, again, this emphasis on how the legal profession and how the courts deal with persons who are not proficient in English is, the new emphasis on this is fairly recent. And so, quite frankly, the courts and the agencies that provide guidance to lawyers on ethics just haven't worked through a lot of these problems. In fact, there are no rules of professional conduct that currently bind Georgia lawyers that speak directly to the representation of LEP persons. But there are a number of the rules that are implicated by special issues and challenges that come up with respect to representing somebody who is not proficient in English. Now, we're focused mostly on representing LEP persons in the context of litigation, representing them in connection with litigation. But I want to break out our discussion of the ethical issues into two parts. Even when you represent a client in litigation, there are two aspects to your representation. One is your representation of that client before you ever walk in the courtroom. Your consultations with the client, your preparation to go into the courtroom, your attempts to talk to your client, talk to witnesses, investigate the matter, get a sense of what's going on, but also talk to the client about what they want out of the representation. And then, of course, there is your advocacy in the well of the court on behalf of your client. And I want to treat those separately because I think they raise some distinct issues. Let's start with the ethical responsibilities of a lawyer representing a client in litigation before you ever step foot in the courthouse. And I want to start with some of the rules that touch on this. Now, in a lot of discussions about the representation of clients who are not proficient in English, a lot of folks start with Rule 1.1, which goes to the competence of a lawyer. I'm not sure Rule 1.1 touches so much on language issues. Rule 1.1 is couched in terms of legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Your understanding of language issues, your ability to communicate with the client, we all know that's integral to the lawyer-client relationship, but that's not really, in my view, what Rule 1.1 is about. And some of the commentators have debated and disagreed about whether the competence rule really touches on it. But I think there are other rules that more directly implicate the issues that you have in representing folks who just are not proficient in English. The first one is Rule 1.2. Rule 1.2 stands for the idea that the client ultimately is the master of the representation. Rule 1.2 says, a lawyer shall abide by a client's decisions concerning the scope and objectives of representation and shall consult with the client as to the means by which they are to be pursued. To that end, we have Rule 1.4. Rule 1.4 talks about the consultations that you have to have with your client to enable them to make the decisions about the scope and objectives of representation. Rule 1.4a says, a lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent is required by the rules, shall reasonably consult with the client about the means by which the client's objectives are to be accomplished, shall keep the client reasonably informed about the status of the matter. And Rule 1.4b says a lawyer shall explain a matter to the client to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. As the comments to the rule say, reasonable communication between the lawyer and the client is necessary for the client to effectively participate in the representation. You have got to enable your client to make informed decisions about the objectives and scope of representation. If you cannot do that, you cannot effectively represent someone. The comments go on to say the client should have sufficient understanding to participate intelligently in the decisions concerning the objectives of the representation and the means by which they are to be pursued. Now, sometimes you have a client who, for a number of reasons, can't participate in representing their own interests and being an advocate for themselves to the same extent that the usual client can. And the rules require special solicitude for the interests of persons who aren't capable. It's Rule 1.14. It's clients with diminished capacity. Now, the commentators have talked about this a little bit. I don't think the rule about diminished capacity goes directly to someone whose only disability, in a sense, is their limited proficiency in English. But I think by analogy, there's a lot we can learn from the guidance given in Rule 1.14 to lawyers who are dealing with clients who have diminished capacity. Rule 1.14 says, when a client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of minority, mental impairment, or any other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship. Now, that said, the idea of a normal client-lawyer relationship is premised on the assumption that the client can be properly advised and assisted, and then is capable of making intelligent decisions about the important matters in the representation. If you can't communicate effectively with your client, in some sense they are operating under a diminished capacity. That may mean that you need to take special steps to ensure that you can communicate effectively with your client. If you can't do it, perhaps you should decline the representation and let some other lawyer who can make it happen take on the representation, because you have, at the end of the day, the lawyer bears the heaviest responsibility in our system of justice for protecting the interest and rights of their client. And so, the lawyer has to have special solicitude for the interests of a client who, for whatever reason, including, I would suggest, limited English proficiency, may not be able to participate in the decisions about the case to the extent that a usual client could. So, now that's the boring part, kind of going through the rules. So what do you do when an LEP client appears in your office? You understand that they need some help with a litigation matter. Maybe you've been appointed in a criminal matter to represent this client. How do you give them enough information to equip them to make informed and intelligent decisions about the objectives and scope of the representation? Well, first of all, you have the language challenge. You have actually more challenges than just the language challenge in these cases oftentimes, but let's start with the language challenge. How are you going to overcome the language challenge? Well, you've got a number of options. A lot of lawyers who represent limited English proficient persons are themselves bilingual, or they have staff at their law office who are bilingual. And so oftentimes you may try to communicate in the client's native language yourself. If you are proficient in the language, you may rely on the attorney's staff. Now, there's nothing inherently wrong with that, but I would suggest that there are a few things you need to think about when you do that. First of all, that you speak a language does not mean that you speak the particular dialect that your client may speak. That you speak the language does not mean necessarily that you have an understanding of the regional variations that may affect how the client speaks. Now, I come from a little town up in North Georgia called Ball Ground, Georgia. I grew up there. There are about 700 people there, kind of in the foothills of the Appalachian Mountains. And in Ball Ground, we don't speak the Queen's English. And in fact, I remember when my wife and I first started dating, I would say things to her like, "Tonight, let's go up and see Mom and them." And in Ball Ground, that's just how folks talk. In Ball Ground, they would know that when you say, "Let's go see Jana and them," what you mean is, let's go see Jana and the other people, them, who are with Jana. My wife went several months and had no clue what I was talking about when I said, "Let's go see Mom and them." She finally asked, she said, "You don't have anybody in your family named M. What in the world are you talking about?" Everybody in Ball Ground, Georgia would have understood what I meant. But outside the foothills of the Appalachians, I'm not sure folks do understand when I talk that way. And so there are all these regional differences. We all speak English, but there are all these slight regional differences that can be important even in everyday conversation. But the importance is magnified when you're talking about somebody's life, liberty, or property being on the line, and you're about to walk into a courtroom to represent them. So that's one danger is, if you're going to rely on your own language skills, if you're going to rely on your staff's language skills to communicate with a client, you better be sure that that will result in effective communication, or at least reasonably sure. We can never be absolutely certain of these things. There's another risk. If you're relying on your staff, if you don't speak the language, but you have a staff member who says, "I speak the language, I can talk to this client." How can you know, if you don't speak the language yourself, that your staff is doing a competent job, especially if your staff is not trained as a professional interpreter? You can't. Now, I'm not saying that you should never, or that it is unethical to rely on staff. Sometimes that's the best you can do. Sometimes that's the only means at your disposal. But you need to think about these things. You need to think about the fact that you can't, if you don't speak the language, you can't have any assurance that there's effective communication going on between your staff and your client. And that is a danger for you as the lawyer. What if there is a misinterpretation and you were interpreting yourself or your staff was? Is that professional malpractice? Does that raise malpractice issues for the lawyer? Are you liable for negligence if that misinterpretation, if that misunderstanding leads to a bad result in court? That's not clear. That's not really been hashed out in the courts. I don't know that we have a clear answer to that question at this point. But it's something you certainly ought to think about. Now, if you're not bilingual, if you don't speak the client's language and dialect, and your staff doesn't either, where's the next place you might naturally turn? Well, there might be somebody who comes into the office with the client, family, a friend of the client who is bilingual. And so you turn to that person to interpret. Now, the first question is it reasonable for you to rely on this person who you don't know that they're actually giving you an accurate interpretation? Probably depends on the circumstances, but you need to at least ask some questions of them, especially about their relationship with the client, so that you can have some assurance that they understand what the client is saying in the client's native tongue. But you also need to have an understanding with them about what their role is. Because quite often when you rely on somebody who's not trained professionally as an interpreter, you will ask the client a question. They will interpret the question, but maybe they will rephrase it in the interpretation, and actually, in the client's native tongue, ask the client what the interpreter thinks you're trying to get at, not what you actually said. And then the client gives an answer in their native tongue, and you have no idea, because you don't speak that language, what it is the client has said. And then, in an effort to be helpful, usually it's not malicious, these are folks who are trying to be helpful, they will rephrase, they will recast what the answer is in an effort to kind of cut to the chase, get to what they think the lawyer's looking for. That is not what you want when you interview a client. If you were interviewing a client under optimal conditions, if you were interviewing a client in English, you would never want your questions to go through an intermediary, and the intermediary to rephrase the questions and also rephrase the answers. No lawyer in their right mind would want to conduct a client interview that way. So that's a real problem. Also, you have the issue of the family member or friend may have some bias or interest in the outcome of these proceedings, and that may influence how they are interpreting for your client. And remember, going back to the rule on diminished capacity, it actually gives some guidance in this area. When you're dealing with a client who has diminished capacity, the rules say you can rely on family members especially to help you have discussions with the client, to help them come to decisions about the representation, but you have to be very careful when you do that. The rule says the lawyer must keep the client's interest foremost and must look to the client and not to family members to make decisions on the client's behalf. So to the extent you're relying on a family member who may be interested, you have to be very, very careful that the answers you're getting are the client's answers and not the family's answers. Now, relying on a trained interpreter, a professional interpreter, I would suggest that's always the best policy. Again, I am not suggesting that the rules of ethics always require that. Sometimes your client may not be able to afford it. Sometimes you may not be able to afford it. Sometimes time may intervene, and you may have to talk to a client on an emergency matter and give them some advice, and you just can't get to a professional interpreter. But it's always the best course. Now, I said at the beginning, language is one of the challenges, but there's also a cultural challenge that you always need to keep in mind. That's not the focus of my remarks today, but when you're giving advice, the rules make very clear that the advice you give is not only to be influenced by the law, but may properly be influenced by moral, economic, ethical, social, and political considerations that may be relevant to the client's decision. If you don't have an understanding of the culture from which your client comes, it's very difficult to identify those other factors that might be relevant to their decision and might in fact be very, very important to their decision. You have to make some effort if you're going to represent clients who were brought up in a different culture, who live in a different culture, to understand that culture and to understand some of the norms in that culture in representing the client, because otherwise you won't necessarily understand the things that might rationally be very, very important to a client from that culture in making their decisions about the objectives and scope of representation. Now let's jump forward to in the courtroom. What do you have to do as a lawyer in the courtroom when you are representing somebody who is not proficient in English? Your first task is to get a reliable interpreter for those proceedings. Now first, you may walk into court and the judge may say, if you are a bilingual attorney, the judge may say, well, we don't have an interpreter here at the moment, why don't you interpret for your client? That is a mistake. That is a mistake, except in the most compelling and extraordinary circumstances. I think a lawyer should never agree to that. Why not? If you have an understanding of how much mental effort and energy goes into interpreting, and I know Jana may have mentioned this earlier, but I was at a program that Judge Quadra put together a few months ago, and he put me through an excellent exercise. It was a learning experience for me. It was also for the entertainment of the audience, I think. As he started with the next presentation, he had me sit there and interpret, English to English, but interpret word for word what the speaker was saying to the person who was seated next to me. Now, I wasn't even attempting to listen in one language and speak in another. I was going from English to English, just repeating what the speaker had said. After 5 minutes, I was completely exhausted. It is an exhausting task. You know, being a lawyer in court, that can be mentally exhausting too. You have to constantly be thinking, do I need to object to that? Do I need to make a motion? Do I need to ask the judge to send the jury out for a few minutes? You constantly have to be on your toes. If you're trying to do both tasks at once, interpret for your client and also lawyer, you're not going to do either one very well. That's the first problem. The next problem is, we all know lawyers are not supposed to be witnesses in cases where they are advocating as a lawyer. Now, one of the problems is, although in one sense interpreters have a distinct role and are not witnesses, in another sense they are witnesses, especially if you are interpreting for a testifying witness on the stand. Because think about it, what do witnesses do? They observe things and then they come in and tell the jury about them. Well, what does the interpreter do? They're observing testimony by a testifying witness who can't testify in the language the jury can understand, and then the interpreter is reporting to the jury what it is this person had to say. In that sense, at least, the interpreter is a witness in the proceedings. And that's another reason, there are no cases out there discussing whether the no dual role as an advocate and a witness applies to a lawyer who's interpreting, but I would suggest at least a strong argument can be made that rule actually forbids a lawyer to interpret for a testifying witness. Then you also get into the issue of, let's say you're interpreting for your client who's on the stand. Now, they have understood from all your preparations that you are their lawyer. They can say things in confidence to you that they can't say to anybody else. So they're up on the witness stand and they say something to you that happens to be incriminating. Which hat are you wearing? Are you wearing the lawyer hat, in which event their communication to you is going to be privileged? Or are you wearing the interpreter hat, where you're going to have to say what they just told you? Notwithstanding that they may have said it under the impression that you're their lawyer, and if they tell you a secret, you can't divulge it. You avoid these sorts of thorny issues if you just don't agree to be an interpreter when you're also a lawyer. Now, when you're in court, also do not rely on family and friends unless it is absolutely essential. I understand you might go in for a TPO, you need an emergency hearing, you need emergency relief, and there's just nobody else available to interpret, and you're going to have to rely on somebody. But if it is at all avoidable, don't rely on family and friends. You know, you always have the issue of potential bias and interest on the part of the interpreter when you're relying on family and friends. You also have concerns about accuracy when you're relying on somebody who's not trained as a professional interpreter. And here's the thing, if you rely on somebody who's not a professional interpreter in the quiet of your office to have a consultation with the client, you can at least then spend some time after the meeting reflecting on, did I get the sense my client really understood what was going on? Did I get the sense that there was a fair and accurate translation going on? When you're in court, though, you sometimes have to make very quick consultations with your client and make decisions based on those consultations that are going to have irreparable consequences for the client. And so you have to be accurate when you're in the courtroom because there are no do-overs. There's no reflecting on it for a couple of days and then coming back and saying, you know, I'm really not sure they got what we were talking about. Maybe we need to meet again. You don't get that chance in court. So that's a real problem. You need a professional interpreter. A certified interpreter is always best. At least by virtue of licensing or certification, you have some assurance of the reliability of the interpreter. If no certified interpreter is available, voir dire, whoever is offered up as an interpreter, not only about their general qualifications to interpret, but also about whether they spend any time with your client and or the witnesses they're going to be interpreting for, and whether they, in fact, understand the particular dialect that's involved, understand the regional variations, voir dire them about these things. Don't ignore the need for an interpreter in preliminary proceedings. You might think, well, today is just a probable cause hearing, nothing much is going to happen anyway. You know, we'll just go forward, we'll waive an interpreter for this proceeding, obviously we'll need one for trial. The problem is, you go forward with that probable cause hearing without an interpreter, later you ask for one at trial, you know what the first thing the judge is going to say? You didn't ask for one in the probable cause hearing, your client seemed to understand that just fine. I don't think you really need one. As soon as you know that your client may be in need of an interpreter, ask for the interpreter. And don't surprise judges. Judges hate to be surprised. Ultimately, whether to provide an interpreter at the government's expense is going to be the judge's call. And that makes sense because the judge is actually on the scene, can interact with the client or witnesses and ascertain whether there's a need for an interpreter. But judges don't like to be surprised. As soon as you know that in that hearing 2 weeks from now, we're probably going to need an interpreter, call the judge's office, call the court administrator, let them know so that they're anticipating it and they're not surprised. Know the law. Know when you and your client are entitled to have an interpreter. And be ready to present that law to the judge. And think about whether you need more than one interpreter. There may be cases in which you need one interpreter to interpret between you and your client at counsel's table and another to deal with the witnesses who are testifying from the stand. Now there are some other benefits to that I'll get to in just a second, but think about how many interpreters you need. If the court won't give you a qualified interpreter, make a record. I was asked recently, have you participated in any cases at the Court of Appeals or the Supreme Court where you have reversed based on the failure to provide an interpreter? I have not. I've seen the issue raised from time to time. The problem is, error doesn't get you a reversal. We all know that as lawyers. It's only harmful error that gets you a reversal. And if you haven't made a record, A, you may not have preserved the error at all, but even if you preserved an objection, if you can't show harm in some way, you're going to have a very difficult time getting any relief from the appellate court. Object and object as often as you need to. Every time, if the judge won't give you an interpreter, every time something happens in that courtroom that your client didn't understand, you object. Because not only are you preserving your objections, you're also letting the jury at least know that your client doesn't know what's going on in here. So maybe they'll empathize with your client a bit and cut them a little slack. And under the Georgia rule, if you don't have a properly licensed and certified interpreter, the rule says the judge is supposed to have the court reporter make a recording of the proceedings. make sure if you don't have a properly licensed interpreter interpreting in your proceedings that there's a recording being made, because that's the only way that you can go back later and show that there was an error in the interpretation and show harm. Now let's say you've gotten a qualified interpreter. Let's say you've gotten a certified. This is the really, really scary part. There is no such thing as a perfect interpretation. No jurisdiction in this country to certify an interpreter requires that they get a 100% accuracy score on their exams. Usually the exams tested somewhere 70 to 80% accuracy. 70 to 80%. Now you understand, it has been said that non-English speaking defendants are not judged on their own words. If you have a really good interpreter, they might be judged on 90, 95, maybe even 99% of their own words. There is still some margin of error. That is inevitable. It is a human enterprise. We all make mistakes from time to time. That's going to happen. And so what do you do to guard against it? Let me give you an example of how this can work. There was a federal court case a number of years ago in New York. It was a drug case, and a big part of the case was some undercover wires, some undercover recordings that had been made by law enforcement. And the defendant in this case had been recorded saying, "Hombre, ni tengo 10 kilos," which was translated to the jury as, "I don't have 10 kilograms." Obviously a reference to cocaine. The problem is, given the particular background of this defendant, where he was from, they referred to a certain unit of Cuban currency as kilos. And it was a common saying of, "Man, I don't even have 10 cents. To show how broke you are. In fact, that's what had been recorded, not "I don't have 10 kilograms. But because of that mistranslation, this defendant was convicted of drug crime. Now there was some relief down the road, but that is an awful result. That's what can happen even with a relatively good interpreter. So how do you guard against it? Well, the first thing you can do, I mentioned earlier, you need to consider how many interpreters are required for this proceeding. If you have one interpreting for the testifying witnesses and another sitting at counsel table with you and your client to interpret for the client, at least there's a second interpreter who, if they hear something that's interpreted from the stand in a questionable way, they can draw it to your attention. If you don't have that, this is actually where you can make good use of bilingual family and friends and bilingual staff. Have them sit on the front row behind counsel's table, and they can listen for things that may have been mistranslated and can at least bring it to your attention so you can explore it in the court proceedings with the court interpreter. Those are some of the things you can do, but that's the really scary thing. Even when you get the judge to give you a well-qualified and as reliable as they can be interpreter, there's still some margin of error. And all it takes is one word going astray, and it means your client's property, it means your client's liberty, it means their life, potentially. And that is the scary thing in representing clients of limited English proficiency. I'm going to turn it over now to Marcelo Cedeno, who I think is going to wrap up the program today. I think his remarks will probably be a lot more informative than mine were, but I do appreciate everybody's attention and appreciate the invitation to come here and talk to you today. Thank you.
Thank you again to Justice Blackwell for those remarks. We really, really appreciate it. And next we have Marcelo Cedeno, whose full bio is in your materials, and I'll just read a little bit of it. But I saw Marcelo do a similar presentation in November, which was really excellent. So I called him and said, "Can you please come and present for us?" And Marcelo is one of the Commission's certified Spanish interpreters. He is also a certified medical interpreter as well. He is a native of Ecuador and is a graduate of Kennesaw State University with a degree in modern language and culture. And he also studied marketing and international business at the Universidad Tecnológica América in Quito, Ecuador. In 2003, he began working in the field of linguistics. He first volunteered as an interpreter with a clinic in Marietta while working on his court certification. In 2004, he became a registered Spanish interpreter with the Commission and then became a certified interpreter in 2007. Without further ado, Marcelo Cedeno.
Thank you. So I just came back from Ecuador. My accent is a little stronger than usual. But thank you very much for coming. And my purpose during this presentation is to show you a little bit more about some of the misconceptions that we, even as interpreters, have about our own language, and especially when we're dealing with attorneys and cases in court, how those misconceptions sometimes can play a big role in your case. Now, I have been an interpreter now for 12 years, but ever since I was a little boy, and this has been more than 30 years ago, my biggest passion was languages. And I wanted to study languages, especially English, but I also studied Italian and French. And as a matter of fact, when I was 8 or 9 years old, and my parents asked me what you want, as a gift for Christmas or or your birthday, what my siblings wanted toys, I wanted books, so that I could teach myself how to speak English, especially. So that is why it's such a slap in the face when someone says to me, like, "Oh, what a nice gift you have. I wish I could have some Rosetta Stones so that I can do your job." Because it is so much than just knowing a language. In order to interpret, there is a series of skills that are required, and not just the knowledge of another language. Like I always like to say, only because you have 2 hands and an ear doesn't mean that you can play the piano. You need to have the skills. It is the same thing with with interpreters and with language. So I'm going to give you some examples, and all of the examples that I'm going to be giving you are in Spanish, and I don't mean to be disrespectful to other languages, but those are some of the words that I have encountered and some of the things that I know first-hand knowledge. For example, when an attorney comes to court sometimes with a bilingual paralegal to interpret, it is always interesting to me to hear the translation or the interpretation of that person. And not because I would doubt that that person knows the language, but as Judge Block will say earlier, one word can make a big difference in the outcome of your case or in the outcome of your patient if you're doing interpretation for the medical setting. For instance, can you see this well? Mm-hmm. The word coche in Spanish, okay? Most of you would know that as a car, right? Especially if you're from Mexico, right? But what if the person is from my country and coche does not mean car, that means stroller. There is a big difference between, let's say, stealing a car and stealing a stroller, right? And oftentimes, I come up with words like that I know it may have different meanings. Like the word banana, it's, there is a different word in every country. So I can assume, even based on the accent of the person I'm interpreting for, that he or she is from a certain region. So I always like to clarify, what do you mean by that? And sometimes they say, well, banana. So when I interpret that into English, the lawyers would say, oh, you didn't know how to say banana? Or you didn't know how to say car? How odd, right? Because the work of a professional interpreter is to make sure that your interpretation is accurate. If I only hear the word coche, I won't know if they're referring to a car or to a stroller. And that's when a professional interpreter, or that is what a professional interpreter should do, to clarify and make sure that the meaning is accurate, right? Same thing with prenda, okay? Do you know what prenda means? Someone who speaks Spanish. Well, prenda has two meanings also. It could mean clothes, where I'm from, it means clothes, but it also means jewelry. That actually happened to an interpreter friend of mine who came up with the word prenda, and it was something that got stolen, and she said, well, she stole my clothes. And that was a big issue because the person had actually stolen jewelry, right? And there's a big difference between also stealing jewelry and stealing clothes. The same word, it was just that where that person was from, the word prenda means jewelry, not clothes. Same thing with carro. Carro to me, in my country, means car. And when I was in Argentina once, and I was telling people how I take my carro to go to work, they would look at me very weird. Because in Argentina, it means carriage. So they thought I was going in a horse in a carriage to work. And that it's a simple word, but it's a big difference, right? Like I have a friend from Argentina, just to give you an example. She kept telling me how she loved to go to the boliche, which is a club. And boliche to me, it's a bowling alley. So I'm thinking, wow, this girl loves sports. And for 3 years, I honestly thought she would go to the bowling alley every Friday night until I realized she was talking about the club, right? Coger, very controversial because it has different meanings. It could mean to grab, to pick up, or to have sexual intercourse. My dad learned this the hard way when he was studying in Israel. And he told a friend of his from Costa Rica, you know, te cojo más tarde, meaning he meant to say, or allegedly he meant to say, I'm going to pick you up later. And for her, the word coger means to have sexual intercourse. So she thought my dad was asking her to do something else, right? And he got a slap. Polvo is another one. It means dust, it means powder, and it can also mean to have sexual intercourse. It's a slang. It actually happened to a friend of mine from Spain. But she was interpreting for a woman that had just given birth, and she had a rash around her vagina. And so the doctor came and said, have you done anything? And she said, yeah, mi esposo me tiró un polvo, which to her it means my husband F me, right? And so she was very, very curious and had to ask more questions, and then she realized that where she's from, or what she meant was she applied some powder. Right? And these are just some examples. Torta, torta for me means cake, but in Mexico it's a sandwich, right? And these are just two countries. There are many countries in Latin America, and this word can mean something completely different elsewhere. And so if you don't know the right word, or if you don't know that this could mean something else, if you're not alert because you're not a, let's say, professional trained interpreter, if you're only bilingual, like if I was in training and I hear the word, let's say, carro, I would say car. And I will know to clarify to make sure that it's not carriage. And that is one of the mistakes that a lot of bilingual people make. It's not so much that they don't know what they're doing, even though to be an interpreter you need to have skill. But there are many, 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 many words that as a professional interpreter, you should be able to know when to clarify it. And that is why it is very important when you, as an interpreter, take the certification test. Sometimes you would hear words like this, right? And that's when people fail. That's why out of 150 people, and not just people, 150 professional interpreters that take the oral certification to become certified with the Supreme Court, about 5 people pass every year. The other 145 don't. When I was in college, 2 of my professors who held PhD in Spanish, they went and took the certification test and they didn't pass. That just shows you that it's not just the knowledge of the language, but it's also skill. This is a very infamous word, the $71 million word, intoxicado. This is a patient that became quadriplegic in a hospital in South Florida back in the 80s because he was taken to the hospital, and it was actually a doctor from Bolivia who diagnosed him as being intoxicated because the mother and the girlfriend said se intoxicó. And what he had, that means food poison. What he had was a very, very bad allergic reaction to something he ate. And he didn't get any treatment, and because of that, he became paraplegic, and the hospital had to pay the family $71 million for malpractice. That is known as the $71 million word. One simple word. I was in a case, well, I guess it wasn't a case, it was a patient, but I was called to interpret a discharge in an emergency room a few years ago. This was a baby, and if you have babies, you know that babies can get very sick very quickly. So this mom had taken the baby to the emergency room, and I guess I was busy or they didn't bother to call me, but they had used a tech who is actually a native speaker of Spanish. And they used her to find out what the problem was. And well, the mom said in Spanish, my baby is constipado. So I said, the translation was, my baby is constipated. And the doctor asked more questions, and they were going to send the baby home on Miralax, which is what they use to help soften stool. And then they called me to do the discharge. And then when I clarified, what do you mean by constipado, they said, well, my baby can't breathe. Because constipado in some countries means congested. And the baby actually had RSV and ended up in the hospital in ICU for like 3 or 4 weeks. But he was almost, going to be discharged on Miralax to help the baby soften the stool because of one word that was misinterpreted by a native Spanish-speaking person. Okay? This is actually an airline advertisement in Spanish. In 1977, this airline was advertising the leather seats, and they hired this company to do the advertisement in Spanish. And they, of course, translated this as vuelan cueros, which in some countries of the Spanish-speaking country means to fly naked. Volar en cueros. To be in cueros means to be naked. So they ended up spending afterwards millions of dollars trying to correct that. Okay? Because of one word. And it's not that it's, it's misinterpreted. It is translated correctly, but they didn't know that in some countries it means something else. And that is also when a professional interpreter comes in handy to clarify all of these gaps or all of these different meanings in words and phrases. A simple color, the color brown in Spanish. How do you say brown in Spanish? Someone who speaks Spanish.
Marrón, café.
Marrón, café. It all depends on what you're talking about, right? In English it's, simply brown. But in Spanish, there are many words for brown. If your hair is brown, in Spanish it's castaño, or if your skin is brown, you call moreno, or the sugar is also moreno. But the word for brown is actually café, which is also the word for coffee, right? So again, when you're only bilingual, you may know, okay, brown means café, but what if someone's talking about the skin color? It could mean something completely different. A simple illness, the one I told you, constipado, it could mean constipated, it could mean congested. If you didn't know that, you do now, but that person who said that baby couldn't go to the bathroom was terribly mistaken and could have caused the death of a baby. Okay, a simple meal. If you study Spanish, you probably know that the 3 meals of the day in Spanish are desayuno, almuerzo, and what else? Cena or merienda. Okay, cena, desayuno, almuerzo, cena. Very simple. Desayuno, you can be sure that you are correct if you call it desayuno. It's after desayuno when things get tricky. Because, I will show you, in Colombia, you may be served a meal after breakfast, which is called medias nueves or media mañana. However, in some part of Mexico, around that time you will be served almuerzo, which is not lunch, it's more like brunch. And of course, in many Spanish-speaking places, almuerzo means lunch, but not everywhere, because in many parts of Mexico, lunch is called la comida. But if you go over to Cuba, Puerto Rico, Colombia, and Peru, la comida means supper, not lunch. And comida also means food. So it makes it even more confusing. Now, even though Ecuador, that's where I'm from, borders both Peru and Colombia, supper isn't called la comida, it is called la merienda. And in pretty much every other country, la merienda means lunch. I didn't know that long time ago. I was interpreting for someone, and they asked about la merienda, and I totally messed up, because I thought they were talking about dinner. And I was like, wow, they don't eat anything for dinner. Because in this particular country, we're talking about a snack, a mid-afternoon snack. Okay? Those are the variations of the Spanish language, which makes it so interesting. As interpreters, we're always studying, believe it or not. And so, not saying that we don't make mistakes, but we, as professional interpreters, should be able to identify these variations and ask for clarifications, where someone who is only bilingual would not be able. And there are so many words and phrases that it would be extremely hard for a bilingual person only to identify all those variations. That's why professional interpreters, we strive really hard every day to learn more and more of the language, so that we don't come across those mistakes. If you're a lawyer, I think we've talked about Rule 1.1. I'm not gonna go into detail, but if you're defending a client, you need to analyze the factual and legal elements of the problem. And I don't think you are able to do that if you don't have the full, accurate information of what is going on. Sometimes I get really concerned when attorneys come to me and say, I don't need you because I speak Spanish, or my secretary speaks Spanish. And I always just stay there and make sure. And 9 out of 10 times, I have to intervene because they mess up somehow. So if you're defending a client, as Judge will say, it is always best or better if you have a professional interpreter, because one word, as you have seen, can make a big difference in your case, in the outcome of the case. Rule of communication, as it was mentioned before, if you don't have full communication with your client, and I see this a lot, unfortunately, defendants go to court and they complain to me, say, this is the first time I see the attorney. They've never come to visit me in jail. He or she has never called me. And sometimes, even though I'm not supposed to advocate for them, I would ask the attorney, he's telling me this or she's telling me this, and they say, well, unfortunately nobody in my office speaks Spanish. And so we're just going to talk now and see what we can do for him or her, which is very sad, because that means that the attorney hasn't analyzed and prepared and gathered all the information to defend that person. This is a brochure that you can find in the Georgia Commission on Interpreters website, and this is for attorneys, and these are information about or on how to work with interpreters. If you are in court, you always ask the questions directly to your client. You never use third person, saying, Mr. Interpreter, ask him to tell me what happened. You always say what happened, and you just let the communication flow on first person. The interpreter is the voice of both parties, so the interpreter is not a third party that is mediating the case. So always, especially if you are in a trial, because everything is being recorded by the court reporter, it will be very confusing once you get the transcript of the trial, if there's a lot of third person, second person, asking this, asking that. So always first person. Never ask the interpreter, here, go and explain my client, the rights, because, I don't speak Spanish and you do. You always, as an attorney, it's your obligation to go and talk to the client. Our obligation as interpreters is to interpret and to convey the meaning of what you're saying. We're not there to explain what's going on, what you're going to do, what you're going to say. But as our job is to convey the meaning as accurately as possible. If you can, brief the interpreter. It's not mandatory, but if you have the time, tell the interpreter a little bit about the case. Sometimes we're called last minute, we don't have any idea, and it's always good for us as interpreters to at least know what we're going to be dealing with, basically for vocabulary purposes and all. Okay. This is one of our rules. This is for interpreters. We need to be impartial all the time. So when you, as attorneys, ask us to do something that violates this rule, we're going to have to say no to you. A lot of attorneys, as I said earlier, they would say to the interpreters, hey, go and talk to my client and explain this, or have him or her sign this paper. We are not allowed to do that. So if an interpreter refuses to do that, don't think that he's not doing his or her job, because we're bounded by these rules, and we're not allowed to have, as I like to say, we're not allowed to have any unsupervised conversation with any of the parties. That is, is part of our rules. This is a case where a victim became an aggressor because of the lack of because of the lack of an interpreter. This happened in New York. A woman called the police because her husband was basically beating her up. And when the police came, of course, they didn't have an interpreter. They didn't have any. The only one who spoke English and Spanish was the husband. So guess what? They asked the husband to interpret, even though he was the aggressor. So she ended up, she was found guilty of domestic violence herself, even though she's the one who called the police, and even though she was the one being abused, simply because the police didn't have an interpreter or someone who could say what was going on. Of course, the husband is not going to incriminate himself, and he's going to try to put the blame on her. And that would be, that could happen for any family members. If you use a family member, whether you like it or not, there's always going to be, some kind of impartiality, right? Some kind of partiality towards one party or the other. You need to have a neutral party that can interpret exactly what is being said and to not favor any of the parties. So I'm going to talk about language access for self-represented litigants, which was the presentation I did before. I had to change it a little bit. But very quickly, the National Centers for State Courts are analyzing now the way to provide language access for all self-represented litigants, because not everyone has an attorney. Not everyone can afford an attorney, and sometimes they go to court and they represent themselves. And it's hard enough, as Judge Blackwell said earlier, if you are English speaking, it's hard enough to go to court, even if you have been born and raised in this country, and you don't have to face a language issue. It's hard enough for you to represent yourself. So imagine how difficult it is for someone who A, does not speak the language, and B, has not been brought up in this country to understand the rules of a court system. So some states are already taking steps to help self-represented litigants with this issue. And now, there have been a lot of controversy about this because a lot of attorneys feel that interpreters would be doing their job, and that's not the case. Interpreters are not going to be giving legal advice. That's the bottom line. But with this new pilot project, what interpreters are going to be doing, and I think it's going to get even bigger, it's providing information to the LEPs outside of court. Information that already exists, but does not exist in their native language. For example, the court system in Alaska now has a family law self-help center website where people can go and find information in different languages and videos as well about domestic violence, and those are provided in the most common languages, which are, Yupik, Spanish, and Tagalog. Okay? So that is, believe it or not, that's a big step, because before there was simply no information or help for anyone who was an LEP and didn't have an attorney. California also has an online self-help center available in several languages, as well as other resources to help self-represented litigants, such as videos that educate people about domestic violence especially, and those are available in several languages. Connecticut has a partnership with New Haven Legal Aid Assistance, and they have created 2 videos. And this is very small, but at least it's a step. And this is to help self-represented litigants with divorce cases, because approximately 85% of those cases involve at least one self-represented party in between 2010 and 2011. So those videos are now offered to the public, and they are narrated in English, Spanish, and Polish. In Minnesota, there's also an online self-help center, which includes several language-linked tabs for people to navigate in their own language. Unfortunately, if you're not one of those prominent languages, let's say if you speak an exotic rare language, you have no help. But at least they're doing something, at least it's a step. Also, Call for Justice in Minneapolis has created a list of pro bono interpreters that would give assistance in 13 different languages. In Ohio, the Supreme Court has translated 27 common court forms into 5 major languages. Those translated forms cover a wide range of topics, from general information to domestic violence, protections, how to file paperwork, and more. Not enough, but at least there's a step. This is my favorite and the most controversial one. This is a pilot program in Fayette County, Kentucky, where a pilot program is now providing access to an interpreter for petitions related to domestic violence. This is 24/7, where the petitioners will complete a bilingual form, which is translated by the interpreter, and the interpreter will translate this to the judge. And in this pilot program, the interpreter has the power, so to speak, to go and file this petition with the court, which is, as I said before, it's not acting as an attorney, it's just simply taking a document to the right window. But they're doing this, and apparently it's working very well. And in Georgia, we're also doing some steps. I haven't actually updated this because I just received new information of some other stuff that Georgia is doing. But we're working in remote interpreting to try to provide language access to more and more people outside of court, and also in remote areas. I know Georgia is trying to work on funding to try to increase the language access programs in all courts. And there's a program, I understand, and I'm still not 100% familiar with it, but it's language access for victims of domestic violence. They're taking this domestic violence very seriously, as they should, and they're trying to provide interpretation and language access to people that have been victims of domestic violence. That is being done in Georgia right now. I'm assuming more and more information will come out soon. Are there any questions? Okay. No, thank you very much.
Thank you again to Marcelo for his presentation and the information that he mentioned. There's actually a hotline, a 24-hour hotline for victims of domestic violence here in Georgia, where either victims, domestic violence advocates, and even law enforcement, they can call that number 24 hours a day, 7 days a week, and receive interpretation services in domestic violence situations. And that's something that has come out of Cherokee County. They are spearheading that initiative, and my understanding is that it has been very, very helpful and successful. And so that is definitely a resource to know. And so now we're going to have our closing remarks. I think we did pretty well with staying close to the time. It is 3:02, so if you did need to have a hard stop and you did need to leave right at 3, we definitely understand and appreciate you for coming. And as I bring up now Dean Morris, we just want to reiterate how much we are appreciative of Atlanta John Marshall Law School for hosting us, not just this year, but last year as well, and being a great supporter. Andrea, who's been over there, she has been just wonderful. So please give her a round of applause. And Bernadette Almost has been our primary liaison between Atlanta John Marshall and our committee, and she's also another co-chair. She's here in the green jacket there. And I think I mentioned earlier, but also Lisa Kreischer, who is the third co-chair, along with Bernadette and myself, who couldn't make it here today because she had to be a lawyer and had to go into court. But we really thank her as well for her leadership. We also have another member of our committee, Tia Holly, who's here, who I just wanted to acknowledge her as well. And a whole list of our committee members, and as I said, our supporting sponsors and contributing sponsors are on the back. I will stay a little bit afterwards if there are any questions. I know some folks that come up to me and had questions on, well, what does it count? What is a legal proceeding for needing an interpreter, and what happens in ADR situations or other sessions? So I will be here afterwards. But without further ado, Dean Morris. Thank you.
Hola. Buongiorno. Guten Tag. Dobra den. Shalom. For many of us, these are the greetings that were used by our ancestors when they came to America. Today, they are the greetings used by a goodly number of first-generation Americans. Most of us take understanding what is being said and written for granted. We speak English in an English-speaking land. There, however, are large groups of people who visit and live here and do not share fluency with our language. What happens to them when they have unwanted encounters with our legal system or seek to press their rights within it? How can we ensure they are given the equal treatment that all of us cherish as one of the cornerstones of our way of life? Those of you gathered here today are taking steps to understand the challenges faced by people with limited English proficiency or limitations on their ability to hear or speak. Today, you attended this program not only to learn about their issues, but also what steps can be taken to ameliorate their effect on access to justice. I am extremely pleased that such a distinguished and devoted group of individuals came to our school to share their knowledge and insights into the problem at hand. I thank them for their fine work and commitment to the needs of others. Let me end, as I promised. I understand, having been a practicing attorney in the length of CLEs, but let me end by reminding each of you that we all took an oath almost every day of our lives. It is from the Pledge of Allegiance, which calls for liberty and justice for all. And being here today, you are honoring that pledge, helping ensure injustice for all. Thank you. Thank you for being here. Come back anytime, and have a safe trip home.